So, the order
Probate order. Probate application, Lordship.
probate application
Yes, Your Lordship.
in the read jurisdiction.
Yes, Your Lordship.
I have no determination, most probably.
Lordship,
My lord. Item number 85. My lord, the 3% incremental, may I bring the other side, my lord, only showing your lordship's order, my lord, at 1 p.m. or at your lordship or 2 p.m. my lord's convenience, my lord.
No, no,
85.
To be mentioned,
We mention, my lord, grateful.
Yes.
85.
No, not, item 1.
Item 1. Yes. Call the list.
My lord, I am for item number 1. A confusion arose on the last occasion. My lord, some they have tried to mislead my lord.
Before my learned friend says anything about it, just a little bird's eye view. This is a matter before your lordships where termination of approximately 26,000 college teachers who are working like as a part-time teacher, as a guest teachers, as a contractual teachers, their termination has been sought by an association. So an association is asking by filing a writ petition before your lordship that all the persons who have been serving for last about 15 years, 20 years, 26 years without naming anything, their service should be terminated. On the very first day, one such associations for whom I am appearing, our member is approximately 2,000. We made an application making a prayer that it will have a devastating effect on us. That was allowed. We are made as one of the parties, and the Honorable Justice Tapobrata Chakraborty specifically recorded the maintainability of the writ petitions that is kept open, and no interim order was granted. They challenged the fact of refusal before the Honorable Division Bench. Matter was kept pending for a long time. Now this has been sent back with a request to expeditiously hear out the matter. I have one humble prayer. I have seen there are large number of petitioners, respondents, UGC, etc. And this kind of matter most likely not going to be end here, because I don't want to use the word political, but it has an implications. When someone asking for a termination of 26,000, he might go up also. All I pray today, I have filed my oppositions, I have served to the writ petitioner, but he has not filed his reply. UGC and others might be there also. All I am praying, let the pleadings, whoever has done, that be exchanged. But I may have a good case, but I don't want to win on a small point, because tomorrow I may lose before the division bench by saying that this point was not taken by your lordship. That point.
Yes.
So today, all I pray, I think all of my learned friends, they would agree with me that all the pleadings may be exchanged among ourselves. Lordship may keep a matter on a particular date, and then lordship hear out the matter.
That would be.
The matter was, the matter was for order exact second. We should be clear. Should be granted liberty to approach the single bench or any, because our appointment is not to be cancelled, my lord. We are not big party. I have taken on an application for it.
My lord,
this application be allowed.
Last time I pointed out, they filed an application. They were absent last time. I pointed out.
I think since the division bench granted the liberty, it is an indication that they should be added. So
let them be added. My lord, what happened?
My lord, my learned friend and my learned senior were not there on the earlier occasion. What happened, Mr. Panda also, my lord, placed before your lordship a judgment of the division bench where, my lord, this notification stands. Mr. Panda had, my lord, submitted before your lordship, and your lordship wanted to know whether this particular notification that is under challenge in this writ petition were assailed before the division bench or not. My lord, we are carrying the public interest litigation. My lord, this was assailed And the, my lord, division bench, even in the review, my lord, said that the UGC notification or the UGC guideline on the basis of which the notification has been challenged, my lord, has no statutory binding effect. Your lordship has the order. Your lordship kept this matter for orders only for the reason that your lordship wanted to be satisfied whether the notification that has been challenged in the writ petition was challenged in the public interest litigation.
May I be permitted?
My lord, that
I am the
has been
petitioner,
done.
my lord.
We have the,
My lord, I am the
My lord,
petitioner. May I be permitted to
Mr.
make my
Pandya
submission?
has the hard copy of the PIL. I have the
One
soft
by
copy.
one,
Lordship
one by
kindly
one.
peruse it.
My lord, I am
My
the
lord, in
petitioner.
view of the division bench judgment, my lord,
My
your
lord.
lordship kindly.
My lord, kindly cease the prayer.
Oh, okay, today, let the application for addition of party be allowed, and I am fixing on one date. Then
And in the meantime, all pleadings may be
all
exchanged.
bidding may be exchanged, and then the court will apply its
This
judicial
judgment
mind.
is
That would
actually
be
in my
better.
My lord,
And don't
Yes.
start shouting.
That would be the appropriate. This judgment in my,
Review also dismissed, my lord.
No, no.
Review also dismissed.
my lord, I
On
will
the
satisfy you. I
self-same
will
issue.
satisfy my lord on that point.
My lord, on the self.
I will satisfy my lord on that.
What is your application? Can 4. So none are opposed.
No.
Can 4.
My lord, I am not opposing can for, but it must be on representative, my lord, representative capacity, my lord, because it will never end, my lord. It will never come to an end. Because what is happening every day, my lord, a batch of persons are coming with an application.
Can 4 filed by whom?
My lord, we are serving, we are the only person service has been approved by the DPR way back in 2010. Now in 2023, they have been charged. Regular selection process with the next for of Calcutta University. Now they have been approved in 2010. We are down there, contractual full-time teacher.
effectively,
Can 4 of 2025. This is an application for addition of party.
My lord, UGC is one of the respondents. UGC is one of the respondents.
Okay, you serve a copy. It would be served. কি বললাম? This is an application.
that will only come when lordship is satisfied. They have got a locus. The first order by the Honorable Justice Topobroto Chakraborty specific recording was maintainability of the writ petition is kept open. So on the next date, first lordship kindly hear us. We'll assail that he doesn't have a locus because he was not one of the participants in the competitions. He is nobody. He is an association. This is not a public interest litigation before your lordships. Once he succeeds, only thereafter merit and others, and then paper publication, everything may happen. Prior to that, as lordship is,
Maintainability point is to be determined
yes,
first.
that be determined
But my lord,
whether he has a locus or not.
In this
If
regard,
he doesn't have a locus, why your lordship would be wasting time? and when there is an order recorded by the coordinate bench sitting singly. There is a specific order that maintainability kept open. So it is not that Lordship will hear out the matter for 7 days and thereafter decide that no, it is not maintainable. It will be wasting of the judicious time of the court. So Lordship may fix the matter on any date that suits your Lordship.
Okay.
But my lord,
Asan.
but my lord, the justice, the order of the Honorable Division Bench presided over by Lord Justice Chakraborty merged into the order passed by the Division Bench presided over by Justice Horace Tandon. That merged, and that order, that is the latest order of the Honorable Division Bench. Nowhere it is mentioned the maintainability should be kept.
No. I will address. Maintainability is kept open.
Nowhere it is mentioned.
No.
In the very
The
first
order of-
order itself of this.
The order of Justice Tapabrata Chakraborty has not been modified. Only the division bench has remanded with a request to expeditiously hear
Division
the
Bench
matter.
has recorded, Honorable Division Bench has recorded the entire facts of this case, my lord.
Lordship will
in
hear out
nutshell.
when Lordship actually takes up the matter, not in this shortcut method. Lordship may kindly see the order dated 24th of February 2020. Direction and what?
10th January 2025.
Yes, my lord.
Yes.
My lord, kindly see
Since
that
the
order.
appeal is against refusal to pass an interim order
Yes.
My lord.
way back in the year 2022.
Correct.
We do not
No,
think
2020.
interference.
We do not think that interference in the instant appeal is warranted. Kindly mark this. So, no interference means existence of Justice
If
Tapabrata.
the petition itself decided on merit.
Yes, correct.
Merit. my lord.
Correct. This merit,
So not on
this
maintainability,
merit
my
is a
lord, on merit.
contextual merit. It does. This merit
Not on
doesn't.
maintainability.
No.
On merit.
No, I will argue. I think this is too small thing to argue on that. This is not a decision by the Honorable Division Bench to the effect that the order of the Honorable Justice Tapabrata Chakraborty recording that maintainability kept open, that is completely diluted. No. Had it been so, then this word, we do not think that interference in the instant appeal. The merit includes. I am not saying the High Court doesn't have jurisdiction. I am saying the petitioners, locus is a part of the merit itself.
But point of maintainability as urged by Mr. Dhar,
Yes.
learned senior advocate appearing for the applicants in CAN 1047 of
Kept open.
2020 is kept open to be decided at the time of final hearing of
Exactly. That is my prayer. And that remains.
Final hearing of the appeal.
Yes.
That means it would be decided at the time of final hearing.
Absolutely right.
Hmm.
Correct. Now,
That
if-
means one of the issue would be whether
Yes.
this petition is maintainable or not.
absolutely one of the issues,
Although this issue is to be decided first.
exactly the order.
If this issue is decided, then no, in the fashion that no, the petition is not
Absolutely.
maintainable.
The order.
Order.
The order of the issues would be number one. is
Number
this.
one, number.
Yes.
Then there would be
Yes.
no requirement to go
Exactly.
into the other issue.
Correct. Otherwise, my lord,
Okay, so I am on consent. I am allowing the addition of party without.
My lord, I have a humble request before you.
Why you are preventing the court?
No, my lord. I have.
What is your request?
Submission. Yes, my lord.
I do not know who is he, my lord.
My lord, in the division bench, I appear before the division bench on CAN 4162, but of 2020, my lord. But that CAN has not been attached with.
Can filed in connection with mandamus appeal.
he
Why
must be
it will
sitting in the
come
same
in the
boat.
writ petition?
My lord,
So my lord, can you seize the problem?
yes, my
One
lord,
person will come,
I
get him
think that
added, and
that-
again this will go on.
the application has already been filed. This application liberty was granted by the division bench to consider, and hence this court is considered. The order which will be passed, it may affect many persons. That not means that every day they will come
My lord,
and
my-
court will go on passing an order for addition of
my
party.
lord, that can
Okay.
that can maybe be added with attached with this.
And I think if this order passed in this writ petition, if adversely affect anyone, he can prefer appeal with a leave to with an application seeking leave before the division bench. That I have been affected.
then my lord,
But if the court go on adding one by one,
no,
carriage of proceedings will be stopped.
Because now we would
No,
be
my lord.
sailing in the same boat.
Yes.
Ultimately, lordship would be hearing locus and the other points.
And
would
the
be
other
hearing
points
if
to be
required.
raised.
So if we succeed, I think that means all of us succeed, minus
Yes.
the writ petitioner.
Yes.
my lord, if,
Okay, আসুন আসুন আচ্ছা
Only
my lord,
half
if,
the
আচ্ছা কি allow the court to pass the order হ্যাঁ কি বললাম for addition of Sir, injunction against
My lord,
filing a suit.
one humble prayer, my lord, one humble prayer, my lord. My lord, kindly records our submission because it will be a repetition, my lord, in view of the division bench judgment passed in, my lord.
Okay.
My
Here,
lord,
this
on-
issue would be addressed. Don't worry, this issue would be addressed. Let the exchange of pleadings
This
be completed.
need not to be dragged, my lord, just by placing.
Okay,
a
on
petition.
that date, it would be considered.
I'm
Don't hear all the issue which should be raised by you.
I am
will
my lord,
adequately dealt with.
Grateful, my
my
lord.
lord, since I am not challenging the service of any particular candidate, I am only challenging a notification.
No, your
So in that case, my lord,
challenge will affect
the
all of us.
notification may
Division
adversely
bench,
affect
my
the
lord,
others.
division
Okay,
bench already
on
upheld the
that
notification.
date, you will place your case. You are the writ petition,
My lord.
that notification, and it has been submitted, submission has been advanced on behalf of the other parties to this proceeding, that this notification was also challenged in a
That I will satisfy my lord.
in
I
a
will
public
satisfy.
inter-litigation. However, and the notification was issued based on a notification issued by the UGC.
UGC.
Now the division bench in a public inter-litigation has decided that such notification of the UGC has no statutory force.
My lord.
No, my lord, no. I do not join
Thereafter,
the issue, my
the
lord.
notification,
Totally misleading, my lord.
okay,
Totally misleading.
on that date, preserve your energy. Preserve your energy for the day.
Copy should be served within
Eh,
a week.
Serve.
Hey,
I am not passing any order. You serve. Yes. By
স্যার আমাদের
course of-
কষ্ট দেখেছিলেন তো স্যার
হুম, ওকে। আর গুপ্তাজির নামটা বড় করে লিখে দেবেন, বললে।
Again, I have.
ওকে।
So this,
my lord has
Okay.
fixed on, my lord.
29th August at 2 p.m.
this matter actually have a huge impact on all the college teachers.
Oh,
If writ petition succeeds, result would be 50% of the teacher who are serving in West Bengal, they have to be terminated. So it is important.
And the
so first, yes, Saha, I am asking two questions. First, the court is to decide whether the writ petition is maintainable or not, and whether this notification
Was
can be stated to have any statutory force or not.
just
My lord, I will try to satisfy my
These
lord.
2 points satisfy, I think.
I will try to satisfy my lord's
that is
conscience.
the qualifying round.
Yes, next. Huh? But your land,
Paragraph 46 instead of UGC.
কোনটা? But your learned friend is not.
Millard,
Your learned friend
yes, yes.
stated.
my learned esteemed friend Millard, page 46, instead of paragraph 46, Millard, page 31. The chairman of the University Grants Commission, Millard, should be replaced with the word, Millard, the AICT. Why? January 2019 and March 2019, two notifications, Millard, possibly will set all the dispute at rest, and Millard, possibly there will be no further query on his part. Kindly chance, Millard, their opposition.
Again, I am to
No, only correction.
open opposition. Huh?
No, since he has raised a very serious question, Millard, that there is no, I am under obligation, Millard, to point out that
It is a correction, like a correction under 152, only typographical correction. If correction is required going through the pleadings again, then application, modification,
Millard, kindly
application.
cease, Millard, only 1 minute, I will take, Millard.
You agree to the.
No, there
Huh?
is no question of consensus, Millard. The consensus, Millard, will not, Millard, change the course of judicial process. Kindly cease. It's a thinking, not a feeling. Advertisement, Millard, kindly cease, page 24 of the opposition, dated 3rd January 2019. The Goni Khan in Chaudhuri Institute. This is, Millard, 3rd January 2019. Then comes, my lord, page,
Okay, I have no
Just a minute.
opposition page.
3rd January, it starts from 3rd January to page 24.
Page 24.
Relevant page is 25.
Yes.
Assistant Professor, PG, yes, whatever. Now, my lord, kindly comes to page 55. This is a corrigendum to advertisement 3rd January 2019, which is at page 24. It says dated, my lord, 20th March 2029. And next page 56, eligibility criteria for faculty positions in different departments of, that is Gunikhan Malda, amended as per AICT norms published in Gazette. And my post here, I said,
Page
56,
50.
heading, 5-6 heading, internal page 43. Yes. This is, sorry, exception, sorry, handwritten page 56. Eligibility criteria for faculty positions in different departments at GKCET, that is Gonikhan, Malda, have been amended as per AICT norms published in the Gazette notification, file number such and such. My post is Associate Professor, Millard, amended or read as. হ্যাঁ 56 নম্বর পাতাটাই দেখাচ্ছে, পরিষ্কার দেখা যাচ্ছে।
Actually, you come to page 25 again.
Yes.
PhD degree in accordance with University Grant Commission.
This was, Millard, a previous position.
It was not any technical qualification.
Millard, kindly see, is associate professor. This is absolutely associate professor. Previously, what was written kindly comes to page 56. As per advertisement 3/1/29. Your lordship has just pointed out page 25.
Okay, yeah. Mr. Jahan.
He has conducted the entire process as per AICT.
Yes, my lord. Just give me 2 minutes. I will my lord, remove.
This is their notification. I am bound by this.
Yes, but you didn't go. You have not gone through the entire thing.
Oh, then
Yes, it's
okay.
kindly come to page 29. The notification which my learned senior friend is referring, that's the 1st March 2019, which we have to follow. Page 29.
আবার সে একই কথা বলছে।
না, আপনি যেটা দেখাচ্ছেন সেটাই কোন
আমি কিছুই দেখিনি, আমি সংশোধিত দেখিয়েছি, পূর্বাবস্থা
আমি
দেখিয়েছি।
সেই নোটিফিকেশনটাই দেখাচ্ছি
হ্যাঁ,
আপনাকে। This is the latest
আছে।
notification.
ঠিক আছে।
Now, my lord, what this notification says, kindly come to page 39. That's
Millard, the time has come, Millard, to start our journey from the fundamentals and elementary thing. The time has come, and that is why that is the process, Millard. We are wasting the court's time, and it's a public time. We are guided by our advertisement. No need to go further and anywhere. Page 56 is the answer to the
attitude, my lord,
No,
I must say.
No,
Because
it is not an
says-
attitude.
It says we are guided by 2019. Now,
It-
2019
no,
itself says,
where-
if it's a post of science, then this is to be, my lord, have a look 5.
Millard,
5F says, then it is to be guided by
No.
so and so minimum qualification.
absolutely not.
This is absolutely, my lord, unexpected. This is unexpected.
The world is not, Millard, obliged to dance with the tune of his
Everything can
expectation.
go as per
The
your.
world is not,
Why?
kindly page 40.
So
and
in that
46.
circumstances, I have no other alternative but to invite an application for modification.
Millard,
Because of
Millard,
the fact, if it is,
with deepest respect, Millard, in a disposed of matter, no application for modification lies, only review lies. It is a Supreme Court judgment, only extension of time lies. I cannot, Millard, mislead the court, Millard, for the sake of my client's interest. No application for modification lies in respect of.
okay, you file appropriate application according to you.
My client has
Sir,
lost
we
his
are
father
bound
after
by-
this
we
winning,
are
Millard.
bound by
Overwhelming, Millard,
2019
winning,
AICTE
Millard.
guideline.
Millard,
AICTE guideline
Millard,
says.
Millard,
this
they
is
have
to be
preferred an
dealt with.
appeal. They only want to get it heard by the appellate court, and that is why this obstacle. It is a conscious choice. It's a conscious attempt, Millard, to thwart, Millard, to delay the process.
But
We
he's
understand,
maligning
not by
us, my lord.
accident,
He's maligning us.
not by accident, but by design.
Well,
Take your lordship.
kindly take up the.
What is the-
So,
Millard, what is the
so
point?
the appeal has been prepared.
Appeal has been preferred. Appeal
So
has been preferred.
appeal court also will consider.
No, question is, Millard, that there is it is a high court, Millard, the record, Millard, if the record is not, Millard, corrected, it has to be corrected. Your lordship was all the time very meticulous, Millard, with regard to the correctness of the record. So record must be corrected. So I am only saying, first of all, if it is the contention of my learned esteemed friend that he is not guided by the advertisement, and the advertisement, my lord, amended and previous position does not relate, my lord, to my appointment to the post. Associate professor previously, he is right. It was guided by the UGC, that was said. But amended notification, the moment it comes, page 56, my lord, kindly see, it's only one line. Page 40 and 56 we read together. No UGC story, my lord. Kindly turn page 40 first. This is the qualification AICTE regulation for associate professor. I applied for direct recruitment. I applied for direct recruitment for the post of associate professor, my lord, clear. I hope, my lord, my learned esteemed friend will not give any objection to that proposition also, the question of fact. I applied for, this is the qualifications, my lord, enumerated in for direct recruitment, my lord, for the post of associate professor. I applied for the post, number 1, page 56, my lord, kindly see, associate professor. As per advertisement number, previous position was, my lord, under the UGC. Amended says, my lord, kindly, my lord, takes pain to turn your lordship's page 56. Amended or read, my lord, it says same as 40. Page 40 and 56. Your lordship need not, my lord, rely on the statement made at the bar. Don't rely on my submission. But kindly, my lord, eradicate, my lord, the confusion between the ears and the eyes.
Okay, court directed the chairman to appoint a person.
Instead of UGC, it is AICTE. On the one hand, your advertisement, I am guided by the advertisement. That is the guiding poster.
So it is not mere a typographical error. So a further determination from the court is required whether the authority would be chairman of the UGC or chairman or director by whatever name
Court has
the highest post is called
I am extremely
of
grateful.
AICTE.
Millard,
In a
kindly.
disposed of matter, such determination is required. Therefore, a further application is required.
Millard, I tell you, lordship.
If it is typographical, you know very well better than
Millard, this is Millard. I tell
Okay.
you, lordship,
Ah.
when your entire decision-making process, when your lordship's entire decision-making process, Millard, standing on the floor of understanding of the advertisement, today, Millard, the court cannot be oblivious of the fact that this requires, Millard, the further consideration on merit, subject to correction. If your lordship is not satisfied, I cannot impose myself on the court. I only require, my lord, to draw your lordship's kind attention whether the conjoint reading of page 40 and 56 will, my lord, set all the disputes at rest. Then I will stop my journey here. I will not embark upon further inquiry, thereby, my lord, destroying, my lord, your lordship's valuable time. Only page 40 and 56.
your submission is being disputed by your
Millard, dispute has to be tested, Millard. Whether it is a dispute, Millard, which need to be gone into. The court cannot, Millard. The court is not unmindful of the Millard, essence of the element of the advertisement. Kindly, Millard, takes time. Kindly, Millard, apply your lordship's mind whether, Millard, the submission made by my learned esteemed friend and I, Millard, whether.
So the determination is required,
No,
not
Millard,
mere
only, Millard,
typographical.
40 and 56.
আসুন আচ্ছা
In item number, I am for the petitioner, my lord. My petitioner is being appointed as assistant teacher in the year 2009, my lord. Before his appointment, my lord, he admitted in master degree examination, and thereafter in the year 2010, my lord, he also appeared in master degree examination, my lord. He pays for higher scale to the authority. My lord, the higher scale application has not been considered, my lord, till now, my lord. My humble respectful submission before lordship, kindly direction be given to the DI for consideration of my higher scale, my lord.
When you
My lord,
join,
page 34,
when you join, you change that date.
2009.
Nine.
14 September 2009.
14 September 2009.
He has admitted in the session for master degree,
হ্যাঁ।
2008-2009 session.
2008-2009 session. তার মানে prior to
Prior to. So according to Utpal Kanti,
Utpal Kanti Karan, he is entitled.
my lord.
the matter is pending before the DI. Well, Lordship, kindly the representation at page, page what?
38.
38.
My lord, this after taking the resolution of by the school authority, matter referred to the my lord, the
Also, the present petition has been prepared. আসুন সুমন বাবু prepared citing inaction on the part of the
Item number 4.
I am for the petitioner, my lord.
Yes. Who is your other side?
We have served the copy, my lord.
Eh?
We have served the copy.
It is a 2022 matter motion.
Yes,
Served earlier.
my lord. Beforehand, when the matter is appearing, we have said that also the matter shall appear, and the matter is appearing. We have verbally also we
You
have.
are appearing in this matter. Oh. আচ্ছা আপনি ইয়ে করুন ওইটা লিখে দিন আচ্ছা having heard the learned advocate appearing for the respective appealing for the petitioner and
Petitioner father was a license holder of a
oh
rum
yes
spirit and as well as, my lord, the flavored spirit shop, my lord. In 2017, that is in January, he died. Thereafter, my lord, being the eldest son,
when license was granted
license was granted long back, my lord. It is on time to time it was renewed.
renewed yes
That was been renewed, my lord. In 17, when he died, being the eldest son, there were 6 heirs. My father had 6 legal heirs, 3 sons and 3 daughters, my lord. In that, I was the eldest. So I made out in my letterhead as an advocate a communication in March 2018 to the authorities, the excise department, to renew the license in a joint way upon all the legal heirs. That is in page number 21, my lord. I gave out the death certificate, the affidavit, whatever been required, my lord. Thereafter, a hearing took place in February 2020, my lord, where it was been
when
February 2020. That was 12th date, my lord. Just a second.
okay February 2000 12
12th February 2020, page 39.
okay 12 February yes gone
Thereafter, my lord, thereafter the final decision was taken on 20th March 2020.
on 12 February what happened?
There was a hearing, my lord.
Yeah.
The hearing took place.
Okay, final
Where
decision.
they had alleged, my lord, I have suppressed my profession as an advocate, but that was been already stated in 2018 in my letterhead. The advocate letterhead was there, 2018, but still also they made out an allegation. The second fact was there, they issued out a joint license upon the three legal heirs. One legal heir, that is a daughter, declined to go for a joint license, my lord. One was a handicap. My brother was a handicap. He was not been allowed, and I was also excluded. The 3 persons were excluded for a reason why. One was handicapped. One of my sister declined. That is, she doesn't want a joint license upon her. And my was declined because the Advocate Acts 49(1), section 49(1), give out a special power to the Bar Council of India to make rules, my lord. And the rules which were been taken into consideration was from rule 47 to 51 of the Bar Council rules, my lord. In 47, it states out an advocate can engage into business, but not inheritance. It doesn't talk about inheritance. But rule number 50 says out in regard to inheritance of the family business. If it has been inherited in accordance to the family business, my lord, I can go for, but provided that I should not participate in the management of the business. So I'm ready to give out a declaration. So, my lord, in the meantime, recently I go for an RTI, my lord. In RTA also, the excise department gave out an information to me where it states out, my lord, they issued a joint license upon all the legal heirs that were being issued beforehand. That is the 3 legal heirs. My lord, can it be taken into consideration, my lord?
Have you made them party?
Which, to whom, my lord?
Those 3 legal heirs?
They already, my lord. It's there in the writ petition, my lord.
Okay.
My lord, even if I say
So now you want your inclusion of your name.
Yes, ma'am. One more thing,
In
I
the-
should place out one judgment of the Supreme Court also. And
RTI,
read to-
whatever, my lord, I am not privy to this document.
it
What
can-
You give a copy.
I am given a copy, my lord. Even, my lord, one judgment I'll place out. The retrospective application cannot be taken into consideration where the Supreme Court, in regard to West Bengal Premises Tenancy Act, has decided upon on the issue of inheritance, where it has inheritance and as well as the retrospective application of the 1997 Act cannot be applicable on 56, my lord. Can it be taken, my lord?
That does not
The
require
page-
any judgment.
Well, it's required because on the last occasion, my learned friend has come up with this issue. My lord, the para number 21, my lord, can it
দাদা,
be
একটু
taken,
দেবে
my lord?
judgment?
আপনি লিখে নিন না এটা।
আরে, তোমার থেকে কি করে দেখবো তুমি?
আমি আর কোত্থেকে দেবো?
ঠিক আছে,
এত কপি কোত্থেকে দেবো?
তো মক্কেল দেবে, তো মক্কেল
My lord, that is page number 28, internal page number 28, my lord.
Yes.
It is true that the legislature can restrict hereditably by amending or repealing the law as the case might be. The division bench finding in the impugned judgment dated 18/12/2022 is that since the legislature can restrict the heritability is done precisely that is in the 1997 Act by adding the word 5 years from the date of death of such tenant or from the date coming in force of this Act, whichever is later. Hence, as per the division bench of the Calcutta High Court, the death of S.K. Mitra in 1970 also stands covered under the new Act. In other words, 1997 Act changes the heritable rights retrospectively according to the division bench of the Calcutta High Court. Although the actual date when the eviction would happen is post the new Act, but it does not have a retrospective application. As well, and in as such as it is applicable retrospectively to an earlier date, 1970 in the present case, and had taken away the right of the appellant given to them under the old statute. Statutory laws operate from the date of the enforcement, that is prospectively. In the case legislature intend to make a law retrospective, then such an intention of the legislator must show clearly, unambiguously in the statute.
Okay, I've got the copy.
The division.
Yes. I
And
have-
22 also, my lord, because this retrospective application cannot be taken. Another judgment,
Retrospective application of which?
1997, the tenant died in 1970, my lord. So 56 Act was there. He herited in 1970, my lord. Now the Calcutta High Court division.
Okay, in your case, which
My lord,
statute has been given retrospective effect.
occasion, my learned friend has come up. In 2023, they have come out with one circular which is says out that and the license will be issued on a single person. But in 25-26 also they issued upon the all the legal heirs who have been issued a joint license in 2020, my lord. So the point was taken at that moment, my lord.
You show that provision in case of a death of a license holder, how a license shall be granted. That provision.
My lord, that is the joint license is there, my lord. In
Why
accordance
is that
to
provision? That provision
14,
is required.
14.6, my lord, if I take into.
You are saying heritage, inheritance. Whether it is inheritance or
My lord,
first
it can
license.
be taken, the bar rules can be taken, my lord. I've given the bar rules, my lord. At
No
page
bar rule. I want the rule, excise rule.
Well, just a-
I want to know
Just
the
a second.
provision governing the issue of grant of
Just-
license in case of a death of license.
They had
holder.
already issued, my lord. My lord is the rule 14.6 of the excise department notification, my lord. Rule 14, sub rule 6.
What it is said?
My lord, the order can be taken at page number 42, my lord.
Page number?
42 of the order, my lord. My lord, it can be started 42, my lord. As it is clearly laid down in the rule 14.6 of the rules made in the excise department, notification number 800X dated 29/7/2003 as amended, when a license granted by a collector at an existing site lapses on the death of the holder, license of same category in lieu of one lapse shall be granted in favor of one or more heirs or representative of the deceased license along with the surviving partners, surviving joint licensees, if any, at the existing site. If such representatives are willing and eligible to hold the license, the legal heirs at serial number 1, 2, 3, and 4 have been assessed in terms of the two parameters, willingness and eligibility. And it is observed that the Sanjeev Kumar Sarkar
number one is willing but not eligible to.
Okay,
hold a
got
license.
it, got it. So you consider afresh?
Nothing, kindly, my lord. Two things, my lord. First of all, whether it is an inheritable right or not.
Yes.
Legal license. My lord would kindly see our judgment of our court, 2006, volume 4, 414. This is for partition, where this very question came up for consideration.
Yes. Paragraph?
My lord, paragraph 51. My lord, if the suit for partition, my lord would get it from paragraph 1. There's a suit for partition of the estate of one so and so being the parents of the plaintiffs and the defendant. The first, one of the honorable judge's name thereafter. This is a suit for partition. And there the question arose whether, my lord, this legal license is an inheritable right or not. Answering to that, paragraph 51. Sorry, 6-4 CHN 400 CHN 414. This is not inheritable right. First, I have to show the 14.6, which is not holding the field at this moment. That would be
It is not
holding. There has been a new rule has come in 2024. I'll show that rule.
24.
Yes, yes. Because
But-
today,
But you relied upon
my lord,
the rule 14.6
I'll show
when the application was made.
my lord, if today, my lord,
When the application was made,
2018, my lord.
when
2018. So how you can apply
I'll
2024?
my lord, I'll show, my lord.
Hmm.
My lord, I'm next relying on a judgment on this proposition. This is on a issue pertaining to the legal license 2014 SCC 486.
What is the proposition?
Yes, my lord. Kindly come to paragraph 13. 2014 486.
Yes.
It would also be significant to state that as far as the law laid down by this court, the rules which are prevalent on the date when the application is considered, my lord is asking us to be considered today, de novo, what had fallen on the previous occasion, are to be applied and not the date when the application is made. This is also in the legal license case only from West Bengal. So my lord is asking us to de novo consider. Now,
That is another aspect of it.
no, my lord, kindly, my lord, the difficult.
Malayananda Sethi, have you done this dispute cropped up in case of
This is also case. My lord,
frequently cropped up in case of a
no, my lord, kindly see-
compassionate appointment case. Now in Malayananda Sethi's judgment, it was the Honorable Apex Court acknowledged that there is a dispute. Whether
this is the rule 14.6 which was considered. Kindly see the rules. 14.6.
voting.
Well, the not to kindly see the first proviso, provided that where it is not possible to grant the license under this sub rule or to any other representative of the deceased licensee with or without the surviving partner surviving joint license as the case may be, the said license may be granted in all favor of all the surviving partners surviving joint license. So someone can be also expelled, but it is not a matter of right. That is what I am saying. It is not a matter of right. So joint, whoever, 3% are running a shop, 1% expired. He inherits. But he applies for he doesn't inherit, he applies for the license. So that person can be expelled. Now that is considered 14.6. Now, my lord, question is, my lord, my learned friend says he wants to be a sleeping partner. Concept of sleeping partner in a excise license, where is it? My lord, where is it, my lord? A person who is not willing to run, my lord, it is a revenue, my lord would appreciate. This is all a revenue generated. This is not a matter of fundamental right. Legal license, grant of legal license is not a fundamental right. What he is saying, he accepts that there is a specific bar under Rule 50 of the Bar Council. He says, I will be a sleeping partner. What is the concept of a sleeping partner? A person who does not involve himself in the business, and it will not generate any revenue for us. And now the rule, my lord, there is a subsequent rule which my learned friend was saying. If this rule has to be considered, it has to be 1 year. But now it is as per as this rule, my lord, there has to, if I have to consider, I have to consider as per this rule, present rule, which is at page.
Oh, why, Mr. Chakraborty, why you are giving retrospective effect?
No, I'm not giving retro. My lord is asking me to consider his case today. But how can I consider if that rule, whatever rule is present, I have to consider? But that is what I wanted to show the judgment.
He has challenged the order whereby
this is an appealable order. Let him go before the state government. 2020. This is an appealable order under
It's an appealable order.
Yes, yes. Under Rule 85, it is appealable.
So prefer appeal. Go before the appellate.
But my lord, when I talk about the inheritance, my lord,
it
is
not
inheritance.
inheritable right.
Again, you are going to another point.
My lord, I was
Whether order is appealable order, statute has given an alternative remedy.
My lord, 397 of that book, kindly, my lord, 397.
Page 396.
397, my lord. This is a consolidated rules made under section 85. My lord, 397.
Yes.
My lord would find 3. An appeal shall lie to the excise commissioner. My lord, this is an order of excise commissioner. Collector, sorry. My lord, an appeal.
When you paper the present petition.
Well, in 2021, I came up.
When their order was passed?
In 2020, my lord.
21.
220, my lord.
So I'm granting you liberty to go to the.
My lord, the order has been issued by the collector, not the commissioner, my lord.
Collector, appeal.
Because if the commissioner would have come out with this, my lord, it has been stated there.
No.
But because I don't have the book now.
Collector is it as excise commissioner, the order was.
Thereafter, my lord, from excise commissioner, state government, kindly see 4. And an appeal now from excise commissioner, there has an appeal to the state government. So there are 2 fold.
So you preferred appeal?
Well, kindly keep the points open, my lord. Kindly keep the points open. Kindly keep the points open.
And now, so since I am asking him to approach the.
It is all to get. My lord, because the condition was, I was rejected on the condition of BCI rules, my lord.
Yes, you raised this issue before the appellate authority. Before the appellate authority.
Already.
Since appeal lies, then you go.
In regard to the commissioner, my lord, what I saw, my lord, I don't have the books now.
Dekho. An appeal shall lie to the excise commissioner. Excise commissioner কাছে appeal হবে কালেক্টরের থেকে কমিশনের তারপর আবার স্টেটের সেক্রেটারির কাছে তোমার দুটো অ্যাপিলের প্রভিশন আছে
আসুন the present petition has Yes.
I am for the private response.
So, number. Which public land or road? PWD road or public land?
Public,
Public land.
yes.
Whom you approach?
How
I
the
am
read
also
petition is
co-sharer of the,
maintainable?
land.
Huh?
I am
How
also
the-
co-sharer.
Will the dispute
Sharer of
between the
public
lordship private respondent, go to the civil court, how the read petition is
Private.
maintainable?
So to PWD land,
Yes.
the assistant engineer,
Yes.
to whom you have given? BLNR or the executive engineer, director.
No, the assistant engineer is also. Your lordship kindly.
Yes, let the executive engineer consider.
Yes.
Asun.
You know, this is a market area, my lord. Hundreds of.
Yes, 35, my lord.
They are, my lord. Let the authority be decided all the issues, all the illegal construction.
All the issues.
all
No,
the
if the
soft-
You will complicate it more so that the
Yeah,
your encroachment is not detected. Why you have encroached the public land?
No, I have not.
The land of the PWD.
The backside land is.
He is pleased that
Backside plot.
we are having.
I am also co-sharer. Petitioner is also co-sharer. He has occupied the front portion, I have occupied the front portion. And this is a market area, both are continuing business. Now, due to personal grudge, he is my 12th cousin, my lord. Due to personal grudge, my lord, he has taken steps for.
how
What
the,
I
if the lordship,
Page 27, your lordship kindly sees. Malad, assistant engineer, I have made party and I have approached to him, Malad.
assistant engineer, you have made party
Page 27.
and made application to him.
Yes.
Acha. Asun.
Let the petitioner's construction also should be considered.
total
Acha, yeah, the patent petition has
allegation
been
and
prepared
counter allegation is
alleging
made-
inaction on the 12 weeks, 12 weeks.
And private respondent 12 and 13 will also call by for hearing.
Yes, yes.
I have stated,
Yes.
in presence of private respondents, yeah.
2 years later, the captain record.
Actually, the written instruction as produced by Mr. Boyso is taken on record.
A copy of the report may be.
No, no report is there, Lords. Only
It would be given, it would be given.
Go there,
Yeah,
Lords. Go there.
Well,
to collect the
wondering
Lords.
before the court
Lords,
since
this is the-
2021.
that's the meeting, Lords.
And
That's the meeting.
we are wondering before the court since
Fighting
2021,
Lords,
once the court has well,
Have
asked
you
for
got any
report, they are now
copy?
moving, fixing a date.
So it is only for the Lordship.
Your lordship kindly sees their
If the
conduct.
Lordship say, then I am returned.
And there
It is not a document like
They are
CD or anything.
No, Lords, kindly put the document.
That the accused person during investigation, he will be debarred from perusing the
And once
CD.
your lordship call for a report, well, they are fixing a date after the date of hearing.
And the
Lordship kindly
further
sees their
inquiry,
conduct.
further inquiry shall.
First submission is this is a
Okay,
civil
okay,
lordship.
Mr. Mr. Further inquiry shall be conducted in their presence also. So they will be able to
Then
know
Lordship, go there,
But-
Lordship. Go there and collect it for the.
what going to
DLR.
be.
Go there and collect the, what the report has been charged. Go there and collect it.
Good
But
conduct
it
of
is a Lordship, I am Lordship, I am.
If this is the
I am
submission
giving
of
you the-
state, your lordship can
Yes.
understand the conduct of
Only
DLR.
for the report,
After
Lordship. directed only for
2021,
the-
once your lordship.
Okay.
The state submits, this is a civil dispute and
Yes.
fixing a date
For
after
the
the date of
civil
hearing.
dispute.
To other matter in other court.
Everything is clear. Court is functus officio now.
Yes, do other matter in other court. Okay. Yes.
Your Lordship, I am appearing on behalf of the opposite party in item number 7. The advocate on record is suffering from mumps, so that is why I am asking for accommodation for this week.
No, petitioner is not there. Huh? আমি ডিডি করে দিই। None appears on behalf of the petitioner, nor has any accommodation been sought for. Extension of interim order. Oh.
কি করতে হবে না খেতে না
Interim order will expire when? Or already expired?
No, 31st. I'm safe.
31st. আচ্ছা।
না, দরকার নেই। ঠিক আছে, খালি order।
26/12/2022
You are for the, acha, heard the learned advocate appearing for the respective parties. List the matter for further consideration.
I am appearing.
9:30. I am appearing for the respondent number 8, West Bengal Pollution Control Board.
Okay, I am extending interim order.
For a limited period.
Limited period. Okay. আচ্ছা আপনি ইয়ে করে দিন ওই সেম অর্ডার হার দ্য লার্নেড অ্যাডভোকেটস অ্যাপিয়ারিং ফর দ্য রেসপেক্টিভ পার্টিস স্টপ লিস্ট দ্য ম্যাটার
দেখি দেখি স্যার কোনটা এটা আমার ব্রিফ হ্যাঁ আমাকে একটু লিস্টটা দে একটু কজ লিস্টটা দেখি
2247.
22747 না
You have challenged inquiry report.
Yes.
I think thereafter final order punishment has been passed, final order.
Oh, that has been stayed if I'm
Stayed.
not wrong.
Oh, yes.
এটাই তো নাও কত কবে দেয়
You have not challenged the charge sheet.
in another proceedings. Now your lordships, in this writ petition, I'm confining, if I'm not wrong, to 2474, your lordship is having the writ petition.
7019.
দেখো কোনটা আছে কই
এইটা দিন 2474. So shall I take 2474?
that your lordship first. What about this?
So by filing one writ petition, you have challenged the charge sheet. By filing another, you have challenged the inquiry report. And there are three.
That is another, my lord, another writ petition questioning another.
The first one is 22091. My lord, let it be heard first. It is the
First one was filed for what purpose?
My lord, all are different. Charge sheet challenging the charge sheet sometimes inquiry.
Kindly take up the first one. I don't have any,
22091.
I don't have any affection to any of the writ petition. Anyone and can move. এই বিলটা আপনার আছে তো
কোনটা
17 মানে
22091 আছে
হ্যাঁ 22091 আছে তো ফাইন অভিমুগ্ন হতে মতো করতে চাই আপনার সব অস্ত্র থাকলে তবেই করবে But here, your lordships, I have questioned initiation of the disciplinary proceedings by issuing the charge sheet, page 30. So, my lord, the charge sheet is also within the scanner of the writ petition. Then, your lordships, not to give effect of further effect or proceed with the 30 prayer portion with the inquiry proceedings initiated on the basis of charge sheet and the inquiry report. My lord, the petitioner, my lord, is an assistant professor of Vidyasagar University. My lord, now, I take the first point first, that why the charge.
Okay, I'm coming. Petitioner is an assistant professor of?
Assistant professor in English of Vidyasagar University.
Yeah.
By this time, she would have been to be, my lord, the associate professor, but because of the litigation, all that, or the professor also. এটা কি জজ সাহেবের কাছে আছে না তৈরি করেছিলেন জজ সাহেবের কাছে আছে কপি নেই আচ্ছা Malad, I just give in a nutshell, your lordships will be having the charge sheet at page 209. Copy আছে দেবো কই আছে Would you lordships take up this because this is moving from one court to another? I could not get. I prepare the notes of submissions. Proceed with that. If anything to be added, kindly allow me to add it subsequent.
Okay.
এটা তো দেখে দেব
Yes.
Now, Your Lordship, the petitioner joined the service of the university as a lecturer in the comparative literature in the Department of English. My Lord, when he joined, the post was said to be lecturer.
Lecturer,
Now,
yes.
assistant professor.
Yes.
Charge number 1, trying to lower down the image and position of the Honorable Vice Chancellor and the Registrar by impleading them by name with the distorted address in writ petition being such and such number, and sent mails with the defamatory impleadment of them in this said writ petition to the members of the Executive Council, and thus attempted to cause disturbance and to show disregard to the Honorable Vice Chancellor and the Registrar. Well, first I am leaving it. I will take your lordships to the original charge sheet. Whether this allegation, even it is admitted, can be a misconduct. Well, kindly see, this is in relation to the court proceedings, impleading them by name. Well, tomorrow I have certain allegations against a particular person who is holding the chair of Vice Chancellor or the Registrar, maybe. I have impleaded, otherwise my writ petition will not be maintainable if I have an allegation against them. Kindly consider, can it be a charge sheet? Misconduct on my part. Kindly consider from this angle first. Assuming that, take it formal on the face of it that these allegations are correct. Whether can it be a charge sheet, my lord? Can it be a misconduct charge? Now, then, my lord, if this is so, my lord, then probably, my lord, in a case of malice, nobody can move a writ petition before the nobody by impleading. This is your lordship's judgment. If I make a specific allegation against a person, he has to made a part. By name. Otherwise, tomorrow X is the Honorable Vice Chancellor. Tomorrow will be the Y. If I say only Vice Chancellor, there cannot be. This is the first thing. I will take the other point. Charge number 2. Sought for certain information under the Right to Information Act, including funding of foreign trip and tour of the Honorable Vice Chancellor since his joining from 1st November 2011, and the SPIO of University forwarded such information by the letter dated 14 September 2011. The Doinik Statesman published a news item on 3rd November 2012 with the information regarding a charge sheet. What is আমি বলছিলাম তো সাম আপ করেছি চার্জ নাম্বার 2
সেটা আমাকে দাও যেটা
এটা আমার সমাপ্ত দিন আপনি চার্জ দেখুন The Doinik Statesman published a news item on 3rd November 2012 with the information regarding travel and funding of the Vice Chancellor. The University Authority has reasons to believe that it has sent the aforesaid official information to the press without seeking or obtaining any previous sanction of the Executive Council, and the Doinik Statesman published such news item in its Midnapur edition on 3rd November 2012. Such information to the press has been the subject matter of adverse criticism and amounts to an attack of defamatory character upon Vice Chancellor. Again, I am raising the same point. Assuming I have done it, I am not. Is such a information under the Right to Information Act. Because suppose I sought from the SPIO. Who says that SPIO didn't forward it to the press? Just on the presumption is making a charge sheet. This is first. Second, your lordships, even if I have done it, what mistake I have committed? The information given by the SPIO. I have to take the permission. Then if this is so, my lord, nobody can, my lord, venture to come up with the my lord, any public act contrary to law. Nobody can proceed against that just because I am a teacher of the university. See the nature of the charge, ma'am. She made repeated statements in the newspapers which are within the official act of the Vidyasagar University, and published this news item in an incorrect and distorted manner, putting the university authorities to adverse criticism, humiliation, insult, having defamatory character, and she didn't take any prior permission or approval of the university authorities before disclosing the official secret to the public. Malad, even now Supreme Court says that Malad, in sealed envelope, you cannot file a document even before the court. My learned friend is showing Malad, the respondent showing official secret. Malad, I will show to your official secret act, your lordship, which cannot be published and which can be published. Now, second point, your lordships, if it is defamatory, you go before the appropriate court, file a suit for defamation against me. Why do you draw the charge sheet? Because the which you cannot do directly, you are doing it indirectly to punish me. Defamatory suit is a very easy matter. But I find Malad the most toughest job of the drawing up a plaint of defamatory defamation case. The toughest job. So you avoiding that and the consequences of that. You have not given any notice for defamation and said charge sheet because this is within your power. You are showing the power. The charge number 4. See Lord General Diary as well as false complaints with the inspector in charge Kotwali Police Station as well as also the superintendent of police of Mednipur in 2013 and 2014 against Professor Tirthankar Das Purokayasto and also Professor Falguni Chakraborty of the university, and extended the complaint by taking the name of the Vice Chancellor with the allegation that the Vice Chancellor turned a deaf ear to our plea. Well, this is an allegation. If I say I made a representation to the Vice Chancellor against 2 of my colleagues, and Vice Chancellor did not proceed with that or didn't take steps in that, he may be come to ultimately as not a correct allegation. But is it if it might say that Vice Chancellor, Honorable Vice Chancellor turned a deaf ear, is it an allegation, my lord? And to that extent, defamatory allegation. I cannot do that, my lord, as a teacher. And also inflicted discriminatory treatment by issuing show cause notice, and thus inflicted mental harassment upon her. And also put the allegation of mental torture and malafide action using power and authority of the Vice Chancellor without taking any prior sanction and permission from the university. Always they say I have to take permission from the university. 5. He attempted to question the authority and power of the university in various manners. Somebody suppose suspended me without any authority. He may be the register, he may be the dean, he may be. If I find under the regulation or statute, he doesn't have the authority, and I raise that point, for that I have to be subjected to disciplinary proceedings. Can I not raise that point? Now the Supreme Court says even you have to go before the authority who raised it first. There is a judgment. Raise the point of jurisdiction or authority first and then come. This is one of these ideologies looking into. But I am showing that the nature of alleged misconduct on my part. And one such instance is disobeying the university calendar published at the beginning of the academic session. She also attempted to create disturbance and annoyance among the students of the postgraduate studies of English in a planned manner and tried to shift her classes and proposed for arranging classes beyond the regular time, both on weekly holidays as well as public holidays, and questioned the intimation of the registrar regarding the possible problems or trouble to conduct classes without the help of the non-teaching staff during holidays in a sarcastical manner. But I wanted to take additional classes, even during the weekly holidays or sometimes. That created problem with me. And that constituted misconduct. She went on unauthorized absence from time to time in between 1st July 2015 to 31st August 2015. Subsequently filed an application for earned leave by letter dated 31st August 2015, and thereby she disregarded the leave rules of the university and deliberately took recourse to go for unauthorized absence first and then made application to regularize the absence of leave. Normally, earned leave in case of leave, casual leave, earned leave. Earned leave I can ask. If I earned leave, I am conscious of the fact that leave is not a matter of right. But this is not such a thing, your lordship. I find only some substance in this, except other charges your lordship will not find. But this is an arguable. For that, I have to be charge sheeted, I have to be kept suspended for years together. 8 years. And I will show how the disciplinary proceedings was proceeded with. She developed a habit of flouting and violating the notifications and various programs of the university and vindicated her views to the press and social media. For instance, one issued on 24th September 2015 and the others notified on 17th June 2014 and 15th October 2014, 9th February 2015 and 30th June 2015. This is your habit of flouting, violating notification, various programs and vindicated views to the press. They are trying to blocking my voice. Just because I am a teacher, I cannot. If I find something illegal, if I find something irregular in the administration, I cannot raise my voice. Or rather, by issuing charge sheet, you are trying to choke my voice. She was in the habit of making false and baseless and reckless complaints against senior colleagues of her department and thereby ruining the educational atmosphere of the department. It is unfair and unbecoming on her part to bring allegations of sexual harassment upon Professor Das Puroshkar in the public and to malign them with such an allegation time and again, and thereby lower down the image of the university by making it a public issue, even entangling the police department. But I am for the first time looking at it, that in a sexual harassment case, a body comes up with a charge. I have seen the contrary. Even there is no allegation, they have been proceeded with. If this I have made an allegation against a particular professor, right? Because I suffered. And that would be a ground of charge. He acted without and in excess of her jurisdiction since her joining on 1st July 2015 and displayed clear sign of insubordination by sending emails to the Vice Chancellor on October 12, 2015, asking him to forward the email enclosed therewith to all the members of the Executive Council. The petitioner in this petition has internally prayed for a declaration that the initiation of the disciplinary proceedings by charge sheet by the Executive Council of the university is illegal, arbitrary and without jurisdiction, and also prayed for quashing of the charge sheet and the inquiry report. Now I take your lordship. This is the charge of the faction. Now I take your lordships to the points. But first point I have taken that Executive Council, or short EC, of the university has no power, jurisdiction, and authority to initiate disciplinary action against an assistant professor of the university. Why I am saying it, your losses, kindly first. Section 2(7), subsection 7, defines the expression. I will give you lots of the act, statutes, all that. Let me place it, your losses. Employee means in relation to university, any person employed by university. This is employee definition. Section 2, subsection 20 defines expression teacher, appointed by the university or appointed by an affiliated college or institution. Definition of teacher as above must be applicable and confined to the assistant professor and others of affiliated college of the university and not of the university for having specific expression teacher of the university. My lord, why I am saying, my lord, the expression teacher and, my lord, the employee must be applicable to the confined to the assistant professor of the affiliated college of the university, not of the, my lord, university professor. Why I am saying, your lordship, the very next definition. Section 2, subsection 21 of defines the expression teacher of the university, means a professor appointed by the university, either whole-time or part-time, for the purpose of imparting instruction or conducting research in the university. Section 2, subsection 24 defines the expression university professor, means a professor appointed by the university. Section 2, 21, 24 as above are mutually exclusive. Section 10 within bracket 4, subsection 4 vests upon the Vice Chancellor the power to exercise general control and supervision over all teachers, teachers and employees of the university. Section 21 enumerates the power and functions of the EC, and subclause 9 thereof gives power to the EC to appoint teachers and employees of the university and to suspend, discharge, or otherwise punish in accordance with the ordinance. Section 29(1) stipulates university professor to be appointed by the EC on the recommendation of a selection committee consisting of 5 members. Section 29 subsection 2 stipulates a university lecturer to be appointed by the executive council on the recommendation of a selection committee consisting of 5 members enumerated therein. Section 35 subsection 2 stipulates any appeal from an employee of the university in a disciplinary matter shall be referred to tribunal and to be decided and disposed of by the tribunal. No tribunal has yet been constituted under the court by the state government. Now, the provisions of the Amendment Act of 1980. Well, that act, Parent Act, was amended. Section 2, subsection 21, substituted by new clause 21 of section 5 Roman 3 of the Amended Act 2011, page 90 of the petition, and the substituted definition of expression teacher of the university means a professor, associate professor, assistant professor holding a teaching post appointed as such by the university. This was amended. In terms of the express and specific definition, teacher of the university, both in the Amended Act of 2011 and also in the unamended Act 1981, which specifically means and includes assistant professor, the application of the definition of the expression employee is also totally excluded. That is to say, in the case of assistant professor or other teachers of the university, in others' words, definition of employee cannot have any application in the case of any teacher of the university. By section 5, subsection 5 of the Amended Act 2011, well, I have given the page number, the words teacher, wherever it occurs in section 21, in clause 9 of the Act, has been omitted. Now, this is very vital. The word teachers definition has been omitted from section 21. Yes. Therefore, the omission of the word teachers from section 21 of the Act of 1981 takes away the power and functions. That means appointment, suspension, and imposition of punishment of the EC in respect of the teachers of the university and confines it only in respect of the employees of the university. Section 29 of the Act of 1981 completely substituted by new section 29 as incorporated in section 5 subsection 8 of the Amendment Act of 2011 stipulates that university assistant professors is to be appointed by the vice chancellor. Originally it was by the executive council, by the vice chancellor on the recommendation of a selection committee, and the constitution of such selection committee as well as the procedure for holding its meetings are to be in consonance with the UGC regulations and the recruitment rules framed by the state government from time to time. Well, after all this scanning, this provision shows that the EC is no longer appointing authority, and the disciplinary authority of an assistant professor of the university, and the vice chancellor becomes the appointing authority in place of EC. Well, I will take subsequently. I'm just placing it. This is therefore the charge sheet cannot be issued by the executive council. Then, Ordinance 21 stipulates the terms and conditions of service, including leave of all teachers, officers, and the other employees of the university, shall be governed by the provisions of Chapter 15 of this ordinance. Ordinance 22, Chapter 3 deals with disciplinary actions and provides that the teachers, officers, and other employees of the university shall be subject to the provisions of Part 8 of Chapter 15 of this ordinance. Ordinance 88 of Chapter 15, Part 1 defines classification of employees. Such classification do not include teachers of the university. Since Ordinance 88 expressly excludes teachers of the university, the aforesaid Ordinance 22, Chapter 3 are not applicable to the teachers of the university. Ordinance 160 of Chapter 15 of Part 8 stipulates all appeals in disciplinary matters not provided for in Section 35 of the Act are to be decided and disposed of by the Vice Chancellor, except as may be otherwise provided in a contract. there is no such contract existing between the parties. Relevant facts: the petitioner is an assistant professor in English in the university. Charge sheet dated 3rd November 2016 issued by the Registrar of the University as directed by the 8th Executive Council of the University in its meeting dated 25th July 2016 and 19th October respectively. Settled principle of law that the disciplinary proceedings commence with the issuance of the charge sheet. On the day of the issuance of the charge sheet dated 3rd November 2016, in view of the provisions of Section 29 of the Act of 1981 as amended, VC is the appointing authority and not the Executive Council. Upon deletion of the word teacher from Section 21, Roman 9 as amended, EC loses its powers to deal with the teachers of the university, namely professor, associate professor, and assistant professor in disciplinary matters. A conjoint reading of Section 21(9) and Section 29 as amended in 2011 expressly excludes the power of the EC to appoint teachers of the university and to deal with disciplinary matters of the teachers of the university and assistant professor of the university, waste such power upon the VC alone. Thus, disciplinary proceedings can be initiated only by the Vice Chancellor and not by the Executive Council. EC is the apex body of the university. Settled law is that in the absence of any rule, any superior authority who is the controlling authority can initiate disciplinary proceedings and judgment. On this point is, Malad, this is. Not I am telling you, Lordship. This is somewhat appears to be against me. Why I am saying it, your Lordship? If the rule specifies a designated authority, then even there is a higher authority cannot do that. It should be done by the designated. This is my case. Because EC is the apex body, even above the Vice Chancellor. EC was my appointing authority and disciplinary authority. Well, the law was amended in the 2011. Entire power was taken away from the Executive Council and vested in the Vice Chancellor. Then he becomes the only designated authority under the law. So it should be done by the designated authority, not by the highest body. The above citation is clearly applicable to the present case, as there is a specific rule in view of the delegation of power of the EC to deal with disciplinary proceedings against teachers of the university by amending Section 21, subclause 9, and vesting such power on the Vice Chancellor. Thus, Vice Chancellor becomes the designated disciplinary authority, and the VC, being the designated disciplinary authority, can only initiate disciplinary proceedings against the teachers of the university. Malad, this was one of the points on which this Honorable Court was pleased to grant stay on this. There are other vital points I am taking a losses to that. Definition of employee of the university as defined in Section 2 within bracket 7 of the Act of 1981 cannot be applied to include assistant professor of the university for the reason that the word teacher has been specifically omitted by the provision of Section 21, clause Roman 9 of the Act of 1981 as amended in 2011. And when there is a specific definition of the teacher of the university, both in unamended as well as amended provision of Section 20 of subsection 21 of the Act of 1981. Since in view of vesting power as to disciplinary proceedings against the teachers of the university on VC, by the amended provisions of Section 21 Roman 9 in place of ISHI, VC has become the designated disciplinary authority against the teacher, the assistant professor of the university. And ISHI, though the apex body of the university by law, has been divested with the power to deal with the disciplinary proceedings against the teacher of the university. Therefore, EC, after having lost its power in law, cannot usurp up the power of the designated disciplinary authority and initiate disciplinary proceedings against the petitioner in the facts as well as law of the present case. A reference on this point made to the judgment reported in, if an authority designated by statute to perform duty, he can only do it, but situation will be otherwise only in case of Article 311(1) of the Constitution. Well, that's the settled law by this one. I'll give a hand up problem and read your lawsuits. Reference also made to the judgment reported in 1994 5 SCC 346 page 350 to 351 on this point, that the statutory power must be exercised only by the body or officer in whom it has been confided. Now, this is the first point. Second point, your lordships, appointment of the, my lord, inquiry officers suffers from biasness and thus violative of the principle of natural justice. Let me just place it why I'm telling you. The inquiry officer Joyashree Rai, professor of Jadavpur University, was a member of the 7th EC of the university, which framed the charges against the petitioner. And inquiry officer as a member thereof participated and deliberated in the meeting dated such and such and decided steps be taken as per rules by the university in this regard. Malad, kindly Malad, take a note of the fact that the present charge sheet was issued by the 8th EC. So there was earlier another charge which was framed by the 7th EC. And that was in that EC executive committee, the Joyashree Roy was a member of the executive council. In this deliberation dated 26 June 2024 of the petitioner was in consideration. In the present case, charge sheet dated 3rd November 2016, page 44 of the writ petition at pages 47 and 53. The basis of article charge sheeted 7th EC bole dichi in meeting 21st July 2024. 2014, sorry. 21st July 2014. EC. In the present charge sheet dated 3rd November 2016, the basis of article of charge number 4 and imputation of misconduct thereof is the letter dated 26 June 24 of the petitioner. This clearly substantiates that the inquiry officer, being the disciplinary authority as a member of the 7th EC, deliberated on the same material which ultimately formed the basis of the present search, and therefore he was involved in initiating in the disciplinary proceedings against the petitioner. But I'm frankly asking to you, am I clear to your losses? What I'm wanted to be. So there are two proceedings. In the earlier proceedings, the same letter was one of the subject matter in the 7th EC. The present executive inquiry officer was a member of the earlier disciplinary authority. He deliberated on that. And then when this next disciplinary proceedings by the next EC comes up, he was made the executive inquiry officer. He is a party to the decision-making process of charge sheet. In the list of witnesses against serial number 5, page 51 of the present charge sheet, member of the 7th ECs are the witnesses. EO is also one of the witnesses. Kindly see, Malan. Obviously. Now, the above facts substantiate that the EO, being a member of the disciplinary authority, become judge of her own cause, and this constitutes violation of natural justice. Reference on this point made in 3-4 judgment I have said we did note for it. 2009 volume 2 SCC, page 451. 2009 volume 2 SCC, page 451, paragraphs 12, 13 to 18. Departmental bias. This is the new coinage, not too new, your lordships. This has been for the some last few years. Departmental biasness. Here, head of the vigilance department who conducted raid against an employee was appointed as EO. Kindly see the facts. If we tally with this, kindly see. In the earlier meeting, in the earlier charge sheet, he was the decision-making authority as the disciplinary authority. And the subject matter was the said letter. Subsequent charges on the said subject letter, and in which he was making the inquiry officer, who deliberated on the same letter in the earlier occasion. Then 2008 SCC.
The volume has
volume missing. I'm sorry, this volume has to be supplied.
Okay. Ask your junior to find out, yes.
2008 didi volume number te diye debo. 2008 SCC 395.
2009 volume 2 হবে না
No, ওটা হবে next one. 2008 এর ভলিউমটা মিসিং, আমি পরে দিচ্ছি আপনাকে। Page 395, 71, 76 and 78 paragraph. likelihood of biasness is enough to vitiate the proceedings. Amendment made in para 9 of the writ petition and the aforesaid resolutions clearly demonstrate EO was involved in the decision-making process for initiation of the disciplinary proceedings against the petitioner in the earlier proceedings as well as in the present proceedings. Therefore, there is a strong case of likelihood of biasness. Likelihood of biasness is a principle, but strong apprehension is enough, not actual proof, my lord. I need not prove actually, your lordships. Strong apprehension or likelihood is enough for holding that, the biasness. Then 2001 WBLR CAL, এখানেও বোধহয় মনে হচ্ছে ভলিউম হবে রাতুল 2001 WBR CAL 580 paragraph 7 held who issued charge sheet named as witness element of bias is apparent. In the instant case, similarly, EO who being a member of EC deliberated in the decision-making process of initiation of disciplinary is shown as witness in the charge sheet. 2002, volume 2 SCC 290, paragraph 5 and 6, and 2003, volume 16 SCC 6, 5 and 6. I'm slow, 5 and 6. What am I heavy? 2003, 16 SCC, page 116. সবই SCC. 2003, volume 16 SCC, page 116. Paragraph আমি সাপ্লাই করছি আপনাকে. Bias can also be the subject matter and personal bias. Disciplinary authority participates in deciding appeal, suffers from biasness as to subject matter and personal bias. In the instant case, EO as a member of EC participated in the decision-making process for initiation of the disciplinary proceedings, and thus EO would be inherently biased against the petition. These are the second point. Third point, well, this is most vital also, that I am questioning the entire inquiry report. Violation of natural law. After raising objection, I will, after this is I am taking the last one as the first one. I will take your losses to the writ petition itself. After raising objection by the letter dated 9th January 2017, the petitioner appeared before inquiry officer at about 1 p.m. in the inquiry room, except the EO none allowed. But I will be little slow. Kindly again, Malak. After raising objection by the letter dated 9th January 2017, the petitioner appeared before the inquiry officer at about 1 p.m. in the inquiry room, except the inquiry officer none allowed. Two people allowed to be present at any point of time, like EO and teacher under charge sheet. That means the petition or EO, any of the and any one of the witness. Page 77. Therefore, the presenting officer was not present. Above modus operandi to conduct inquiry proceedings is unheard of in any quasi-judicial proceedings. Violative of natural justice, as this act deprived the petitioner of her opportunity to see how questions were put to witness in chief and deposition recorded. Lord, I tell you, lordships here. My lord, this is now well settled. If an employer, I have the inherent right to initiate disciplinary against officer, disciplinary against my employee, in absence of any rules. This is well settled. Now, the only thing in that case, in absence of rules, that you have to follow the natural justice. Well, our High Court, in Sujit Das case, in a school matter, but if I'm not wrong, the special bench, and other matters in the Supreme Court, while defining the expression opportunity of hearing, defined what does it mean? Means charge sheet first, with clear case against the delinquent employee. This is an allegation against you, with imputation of misconduct. List of witnesses and list of documents to be relied upon to substantiate the charge sheet. First, then reply has to be given. Then inquiry officer has to be appointed. Now, what the inquiry officer will do, there must be a presenting officer for the management. He will first, because prosecution side, the employer, he will place the first case. Place of the case means the witness who will authenticate the documents through witness. Deposition of the witnesses will be recorded. When the one witness deposition is recorded, then the delinquent employee will be given a chance to cross-examine. And this will go so long as the witnesses are not completed on the prosecution side. Once it is done and the evidence on the prosecution side is closed, then, your lordships, I should be given an opportunity to place myself as a witness and place my case. And then, my lord, I can bring my witnesses. There are cases where, your lordships, some documents are not lying with me, but those documents are lying with the management. I can call for those documents, subject to proof that relevancy of the documents in the proceedings. Well, this is just like a suit. What we do in the normal civil court. Except, your lordships, strict rule of evidence is not applicable. Only that. So, my lord, this was not at all followed. I will show one by one. This is, my lord, kindly see page 77 of the writ petition. This is factual. That's why I'm placing first with the reference to the writ petition. Others, my lord, the point of law. I will take your lordships from this. Page 77, your lordships kindly consider. Well, this line kindly allow me, this introduction of this is, my lord, the inquiry report. It is evident from this report itself. Kindly allow me to these two paragraphs. How an inquiry officer proceeds with the matter of disciplinary. This report has been prepared by the inquiry officer, who was given the said responsibility by the letter dated 23rd December 2016. It relates to the charge sheet bearing reference dated 3rd November 2016, issued to Dr. Indrani Datta Chaudhary, Assistant Professor, Department of English of Vidyasagar University, sent by the relevant university authority as directed by the 8th Executive Council of the Vidyasagar University. Herein, after Dr. Indrani Datta Chaudhary will be mentioned that TUC, teacher under charge sheet. The inquiry, but I take exception to this language. After all, she is a teacher. She is not an accused in criminal proceedings as a teacher under charge sheet. Anyhow, the teacher behaves with a teacher like this. This is their affair now. The inquiry was conducted by EO on 9th January 2017 and 23rd March 2017. Dates of inquiry was fixed by EO with appropriate information and knowledge of the university administration. The TUC and some witnesses representing VU were called for deposition. While deciding on the names of the witnesses to be called in for hearing, take kindly, my lord, see the language. While deciding on the names of the witnesses to be called in for hearing, who decided, my lord? You see, EO. What witness to be placed before the EO? That to be the domain of the management. It cannot be decided, my lord, by the EO. If he decided, my lord, he becomes the prosecutor. Your lordships, my lord, probably sitting in the court, my lord, your lordships cannot decide that who will be the witness of any of the parties. It is for them to decide. The documents submitted by Vice Vidyasagar University to EO, along with the charge sheet, were issued by EO for making final. Presenting officer on behalf of you, who is not implicated anyway by the charge sheet, handed over all the relevant documents to EO official. Kindly see, presenting officer, you handed over all the relevant documents. But is it the way to hand over? How this is to be handed over? Through witness. Then after all, facts were collected. Facts were collected, my lord. If I go by the first paragraph of the introduction, facts was deduced by the EO. EO evaluated the information provided by all the parties. on receipt of the confidential letter from the register VU dated such and such, EO conveyed consent through subsequent communication. First date of inquiry was decided 9th January 2017. It was decided to be held at the committee room number 1 of Vidyasagar University, administrative building of the Vidyasagar University. TUC and witnesses were contacted through written letter, handed over in person to avoid chances of communication gap while asking for appearance in person on desired dates and times. But I'm taking serious exception to this. Can the EO communicate letter to the witnesses? Unless, your lordships, even in this under the civil procedural code, I am not saying this is applicable. If the witnesses, some witnesses are, my lord, become partisan, then my lord, EO can give with the by issuing a minutes, ask him to be present at best. But this is not the case. EO decided first the names of the witnesses, and then he issued the letters, come and give your deposition. How the EO can do it? This is the job of the representing officer. Then kindly see, two people were present at any point of time. EO and the TUC, or EO and any of one of the witnesses. My lord, I don't proceed further. Suppose, my lord, EO and I am the petitioner is present. Two at any point of time, he says. How he proceed with the disciplinary proceedings? Suppose I am presenting as a witness myself, as a deponent, as a charge sheeted office teacher. The other side will not be present. And who will put the question to me in cross-examination? And who will record that? You alone. Kindly see the next. Or you and any one of the witnesses. Then, my lord, if any witnesses, which one is called by the EO of the management, X, for example, X and EO will be present, and EO will question the witnesses without presence of me and any other presenting officer. What sort of proceedings, my lord, this is? The entire proceedings went on like this. I will take your losses to that. Questionnaires were prepared by EO. What remains, my lord? Questionnaires were prepared by EO. What questions will be put to the witnesses that was prepared by EO? Then EO become the prosecutor. Kindly see, independently. His knowledge is that if I prepare the questionnaire independently, that is enough, without any bias. That signifies, my lord. Questionnaires are prepared by EO independently. That means without anybody's reference, without any assistance. No, that's not the procedure. That's the inherent biasness. And used during each of the depositions. EO and used during each of the depositions. The questionnaire prepared by EO were used during the deposition of the witnesses.
Yes.
Respect for all was followed. I don't know, my lord, what sort of respect. EO made it evident that the matter is of serious nature. As such, as much time was needed for each deposition, it was allowed. EO did not take any biased position and listened carefully, asked follow-up questions, and take note of depositions. Can you see the procedure? Everything was done by the inquiry officer. No presenting officer, none. No, I even do not know what questionnaire was put before it was given to me after the deposition, whether the questions were actually put to the witnesses or what was the answer of the witnesses, whether that was the answer given by the witnesses or it was answer also given by the EO himself or herself. Because 1:1. In camera, 1:1. Then, your lordships, each one's participation in their own way helped in progress and completion of the investigation. EO had to ask for some additional time from VU authority to complete the report given for competing demand on her own time. This procedure, and this is the procedure adopted by the is itself violative of natural justice. Even in I'm going to even in absence of any rules. Presenting officer child.
Yes.
Now kindly come to the next page, Malad. During interview, while video recording was also underway, the video recorded it. EO was also computer typing in proceedings in laptop. The final computer typed versions included all the major points, and it was then showed to the interviewees and were asked for suggesting corrections. Well, what sort of this, Malad? Suggestion corrections. What he has said, right, wrong, right, that has to go to the deposition. By way of putting suggestion, you cannot correct it. And in camera, one-to-one, you did it, everything. Kindly see, once, Malad, I request your lordships, kindly see. The final computer typed versions included all the major points. It was then showed to the interviewees and were asked for suggesting corrections, changes, clarifications to the EO there itself. What the EO was doing, Malad? He was changing the witnesses' views and depositions. It's a manipulation on our part. I do not know what actually they answered to the question. And question prepared by the EO, put by herself. The final edited printed copy of the proceeding was then signed by the EO in presence of the TUC or witnesses, and TUC or also witnesses also signed on the spot. Then your losses again kind. No copies were given to anyone as the inquiry was in progress. Malad, is it the law, Malad? A deposition was given as in examination in chief in a quasi-judicial proceedings. That will not be given to me before cross-examination. Then how can I put a question? First is repetition, my lord. I'm sorry to repeat it. In one, I didn't know. I was not present even at the time of examination in chief by the inquiry officer, not by the presenting officer. And he says no copies were given to anyone as the inquiry was in progress. This is another violation of natural justice. Then how can I cross-examine? I have to make a cross-examination. I can make a suggestion to the witness with reference to his answer to the examination in chief. How do I do it all these? Because you are taking away my bread and butter by these proceedings. Then your losses. This written form of deposition taking was mandatory and was made clear to the TUC and witnesses at the beginning, and they agreed. In addition, arrangement for video recording of depositions was also kept. Whenever needed, EO explained questions in Bangla and English to make interviewees comfortable. A safe arrangement for deposition was set up. Each day's arrangement was in committee room as mentioned above. But I just request your lordships kindly take up this point. I have taken point number 2, Roman 2.
Second point.
All questions put to the witnesses only by EO. Those questionnaires were prepared by herself. Page 77. Once, if your lordships, with repetition, your lordships, from the second paragraph, page 77, from the top, after 7 lines. EO and the TUC or EO or any of the witnesses. 2 people are present at any point of time. Questionnaires were prepared by EO independently and used during each of the depositions. That's my lord, kindly point number 2. Thus, inquiry officer became the prosecutor. This has vitiated the entire inquiry process. Reference is made to the two judgments reported in 2018 7 SCC. 2018 7 SCC. Page. ऐसा बসে থাকবেন না, ভয় লাগে, ভুল বলছি। 2018 7 SCC, page 670, paragraph 25 to 37, and 208, sorry, 2008, 2 CLJ, within bracket SC, Supreme Court, page 238. Then, Malad, kindly see the third paragraph. Paragraph 3 of the note. Inquiry officer herself noted that after interview, that is to say deposition of the witnesses, witnesses were allowed to change, modify, etc. their deposition. This act is illegal, arbitrary, and malafide, amounts to manipulation or fabrication of the deposition, and thus constitutes violation of natural justice. As after deposition, version of witnesses cannot be changed to suit the case of university. This is a glaring example of manipulation of inquiry proceedings by the inquiry officer. Or 4. May I proceed? Page some of the paragraphs here, Lordship. None. Reported. Now, your Lordship, paragraph 79. My Lord. 79. Report. Page. Sorry, page 79. Last paragraph. After careful scrutiny of the written exchanges between the VU and TUC, the following overarching issues are framed. Has the VU any cause of issuance of charge sheet by VU? Kindly see. Has the VU with thus any cause of issuance of charge sheet by VU? He is questioning or deciding the authority of VU. He is the inquiry officer. He will only find the facts, whether charges are proved or not on facts. Nothing else, nothing more. He is saying issue cause for issuance of charge sheet. Can he do that? Can an inquiry officer do this? Kindly see the issue. Has the VU, that means Vidyasagar University, any cause of issuance charge sheet? There cannot be any issue. He will only decide the charge sheet on facts, not even on law. He is the authority of finding of facts. Now kindly see, my lord, 2. Issue frame. Has the TUC teacher under charge sheet behaved in a manner which is a cause of concern for her colleagues and the senior authorities and non-teaching colleagues and cause disturbance and violation of the VU rules and regulations? Is it another charge being framed by the inquiry officer? I'm putting a question to myself. I have placed all the 9 charges.
Yes.
This amounts to framing of charge by the inquiry officer. He cannot frame issue. He has to see only the charges on the basis of the evidence and material placed before him by both the parties. Then, has the VU or colleagues discriminated against TUC based on her gender? I have placed the charge. Was it a charge, my lord?
Yes.
Then, in order to prove the case, TUC and VU witnesses were called for a hearing in front of PO and deposed. PO on behalf of PU presented all relevant documents as desired by you. Kindly see all of this. PO on behalf of VU presented all documents as desired by you. He tutored the entire inquiry. How to be proceeded with. The management case, how to be proceeded with, he tutored. I'm sorry, Malad, C tutored. Kindly this line, kindly your lordships read with this paragraph.
Yes.
I give you
Got it.
This paragraph, what I was placing before your lordships. PO on behalf of the VU presented all relevant documents as desired by the EU. That means list of documents which is to be placed that was decided by the EU. Now your losses kindly see. কি করবে আজকাল?
হয় ইয়ে করুন ওই
8 বছর ধরে সার্কেল হয়ে একটা কথা পাচ্ছি না। করতে পারছি না, মরে যাবে।
Are the learned advocate agreeing for the respective party leaves the matter for further consideration?
My lord, is fixed on tomorrow.
Justice Kapoor.
Yes, my lord, and circuit bench, Jalpaiguri circuit bench. That matter, my lord, fixed on tomorrow. So, my lord, I have to leave right now. Item number 24.
I, along with Justice Arindam Mukherjee.
Oh, yes, yes. I am sorry.
Oh.
That matter is fixed, my lord, for tomorrow.
So your item?
24.
24, okay.
My lord, can you take the matter on 5th of, my lord? But because the appeal is
No, double pair.
24, my lord, I'll make it convenience to other side lawyer, Coal India.
No, double pair cannot be granted.
My lord, only 5th. Only 5th. Otherwise, my lord.
Adjournment and thereafter you will.
No, kindly, my lord, because my lord,
Get it fixed
matter
on
will taken off 3 days. Matter will taken off 3 days, my lord, is the live appeal.
It would be adjourned.
My lord, only can't take it, my lord.
Oh. Yes.
Fixed order, item number 89 to 90.
Well, these matters, my lord, I was submitting on the earlier occasion, but this relates to the Coal India promotion policy, my lord, that two types of certificates. The difficulties, my lord, led by Mr. Mojumdar in this matter. My lord, he has come across some recent judgments on this point. He asked me to pay for an accommodation for 1 or 2 days, my lord. He wants to rely upon those judgments, 2024 and 25 judgments, pat on the point, my lord. So that
As prayed for on behalf of the petitioner, Eligun. As prayed for on behalf of the petitioner, the matter stand adjourned. The matter stand adjourned for a period of 1 week.
Mr. Mujumdar, I'm sorry, madam.
Huh?
Mr. Mujumdar is yet to conclude his submission.
Yes. But he will, I have placed the facts, he will only argue on the points of law and.
Okay.
I thought जी
अच्छा ये आदमी ये की लिखला matter adjourned for a matter stand adjourned. Hold on. List the matter for further consideration under the heading hearing 1 week hence. 1 week hence. 2 weeks.
Can it be on 7th, my lord? If it is
7th
or 2 weeks, my lord.
2 weeks.
2 weeks.
2 weeks hence. Yes. Under the heading for hearing. Yes. Next.
Item number 91.
My lord, I beg to appear on behalf of the petitioner, my lord. This is an application for enforcement of an order, but I would be praying for, my lord, an adjournment because there is a connected, my lord, challenge pending before the Honorable Supreme Court at my client's instance. My lord, what I was praying is subject to Lordship permitting us, let the matter go out of the list with liberty to mention. My lord.
As prayed for on behalf of the petitioner, the
They have said they have filed an appeal before the Supreme Court.
No, I have, there is a challenge to the act by which they have revoked everything.
Not all incentives have been revoked. This is basically an execution in connection with an incentive scheme. All incentive scheme has been revoked henceforth.
That is under challenge. That is why I am saying, my lord, kindly allow me to come.
Let the matter go out of list, liberty to mention.
Asking for that.
Yes, go out of list, liberty to mention.
92.
92. At the bottom, I will for hearing.
Item number 93.
Is your other side?
Practically, when we went to serve on to them, they refused. We mailed them on that. We mentioned the same. Lordship, kindly hear me for 5 minutes. The situation will be clear.
Expertise?
No, Lordship need not to pass any order ex parte.
Yes.
But the difficulty is this: the plight of the litigants is really tough. Won before High Court, tested before division, succeeded. Similar matter went up to Supreme Court on the same connecting matter, succeeded. They have been granted with all the benefits. Here, we have not been granted with any benefit. Contempt is pending. In spite of that, a students' union issuing a notice, thrashing them out from the employment. That is the instant writ petition. Even that notice has been put on halt by the learned court. Subsequently, even today, I am out of employment, out of service, out of salary for last 5-6 months. It's really pathetic, my lord. Kindly hear me for 5 minutes. Thereafter, if your lordship feels that there is the reason to avoid the court in this matter.
You served directly?
I've already served. I've served. They're not accepting. I've mailed their office. Kindly have a look. I have done service with that. Kindly have a look. Their appearance was there. Since they have suffered a interim order before at that material point of time on the
in this court, it will be appear no such notice.
Yes,
Earlier in the month of February.
Kindly have a look. This one. This one.
Only mail. You serve a notice.
I am ready to serve a notice. No issue to that. Lordship, kindly have a look at this.
আপনি ইয়ে করুন
বাবু এই জয়সাব কি বলছেন kindly make it peremptory, no issue.
Having heard the learned advocate appealing for the petitioner and upon perusal of the materials on record, আচ্ছা, I am of the view
with the compilation of the events already.
and file,
Yes,
yeah,
that would be,
you come with the compilation. I am not.
can you
taking
direct, that would be
order.
better for me.
You prepare, and file affidavit service on the returnability.
Great.
Next, Jaku. Jaku, দেখে যান।
Upgraded matters, item number 17.
Bottom.
18.
Bottom.
19.
দেখে যান।
20.
I will not beg to appear for the petitioner. There is a can which I have preferred. The can pertains to addition of parties.
Who filed it?
I preferred, my lord. Petitioner preferred. My lord, in short, my lord, just within 2 lines, I just want to gist
Whom
up
you
the-
want to be added?
My lord, I want to add, my lord, the CVC, Central Vigilance Commission, number 1. Number 2 is, my lord, the Comptroller and Auditors General of India. And number 3 is, my lord, the ROC Calcutta, Register of Companies, my lord.
Have you served upon them?
My lord, I want to add them as a party. If my lord allows my application, then only, my lord, I will add them as a party and serve a copy of the writ petition, my lord. After the disposal or dismissal as per your lordship's discretion, my lord, thereafter, my lord. Before that, my lord,
What is the matter about National Council of
my lord,
Disciplinary Proceedings?
No, my lord, it is not pertaining to disciplinary proceeding, my lord. The petitioner, my lord, in short, my lord, was an employee in CMD, that is, my lord, the
Who is
Creative
your
Division.
other side? Who is your other
My
side?
other side is, my lord, the Union of India, NCSM, that is, my
When
lord,
you served?
my lord,
You
it has been
served long back.
My lord, it has been served, and my lord, in my humble opinion,
It was served on June.
the Union of India was present. At least yesterday also, my lord, the Union of India's advocate was present, my lord.
Who is?
I saw him. I do not know his name, but I saw him, my lord.
Okay, notice.
This is, my lord, the affidavit of service of the main writ petition, my lord.
আচ্ছা আমি লিখুন despite affidavit service is taken on record আপনি লিখুন
And my lord,
filed
I
on behalf
received
of the
my-
petitioner taken on record despite service that respondents are unrepresented. Stop. হ্যাঁ আচ্ছা আপনি লিখে দিন having heard the learned advocate appealing for the petitioner and upon perusal of the record, I am of the view that presence of the representative of the respondent is necessary for effective adjudication of this petition.
My lord.
Stop. In view thereof, the petitioner is directed to serve a notice to the respondent as well as non-appears.
My lord, respondent number
The
3.
respondents intimating that the matter shall be taken up for hearing
My lord, respondent number 3 and 5 are, my lord, the substantial respondents. Should I serve copy to them only?
On 18th. On 18th.
My lord, only respondent number 3 and 5 should I serve, my lord?
No, all respondents.
All respondents.
All respondents. Respondents means all respondents. I think I am not to interpret my order.
My lord, deeply obliged.
21.
18th.
Same.
22.
You are for the petitioner.
This is a matter where the petitioners are seeking absorption in the state government. They are the contractual employees under a scheme launched by the central government. They have been working under the scheme, and there is an implementing agency, a separate body created by the state government in terms of the central government scheme. Under that scheme, they have been working for long. And at one point of time, they moved this honorable court.
So they are not appointed against any sanctioned post?
No, they are under the scheme.
Under the scheme?
Yes. At one.
So where is the scope of regularization?
I'm placing the facts below. At one point of time, the contract was not renewed. So challenging that, they came up before this honorable court. And after a prolonged hearing, and the matter was pending for quite a long time, and thereafter Honorable Mr. Justice I.P. Mukherjee was pleased to dispose of the matter by directing the state government and the implementing agency to consider their case so that they can be regularized. There is an order to that effect. Subsequently, they have been given job. They are again working under the contract. But although similarly situated, similarly placed employees have been absorbed, these petitioners have not been absorbed. This is the sum and substance of the matter. My lord, I have come across one judgment of your lordship very recently, where in a similar situation, your lordship was pleased to direct for absorption of the employees and working under the scheme, contractual employees, absolutely similar to my case, where your lordship has been pleased to direct the state government to absorb the petitioners in the regular employment against vacancies. Now, the implementing agency through whom the petitioners will be absorbed, they have their vacancies. They are including or recruiting the employees on a regular basis. So there is no case that they cannot be, absorbed.
Actually, a coordinate bench directed the respondents to file affidavit in opposition.
Yes, and they have filed. The affidavits are on record.
Where? No affidavits have been filed in the court. Affidavit in reply. I have got one affidavit in reply.
Yes, that is my reply.
So where is the affidavit in
opposition has been
opposition?
used by
Affidavit in opposition. One application for stay. You are appearing for?
I'm appearing for the state, your lordship.
State.
Yes, your lordship.
The
For
respondent
the ARD
was,
department.
eh?
For the ARD department.
Respondent were directed to file affidavit in opposition.
Your lordship, in the meantime, we have filed one supplementary affidavit. Your lordship, I am.
You have filed?
Yes, your lordship, a supplementary affidavit.
Where is that
the government has used the affidavit. It is 10th August 2022.
Your lordship, I'm placing before your lordship.
Have you served the copy?
Supplementary affidavit I have not got.
Your lordship, this was filed in the meanwhile, the matter was running in the list. This is
A supplementary affidavit filed on behalf of the petitioner. Supplementary affidavit. Have you filed affidavit in opposition?
Your lordship.
Where is that affidavit in opposition?
It is.
You, madam, just say supplementary. The word supplementary comes when?
Your lordship, an opposition had already been filed, but we were not engaged at that time. This is a
Where
change
is
brief,
the
your lordship.
Where is the opposition?
I've got the copy.
Opposition.
I've received the
Opposition,
opposition,
affidavit
I've used the
opposition is
reply.
not with the record.
I've used the reply that is on record.
Affidavit in opposition not with the record. Unless there is an affidavit, can any supplementary affidavit be filed? Supplementary means what is that?
Your Lordship.
Means something more.
Something more change of circumstance.
In
that I-
addition to the
If
original one.
something is not there, how more will come?
রিপ্লাই রয়েছে আপনাদের অ্যাফিডেভিট ইন অপোজিশনের কপিও আমার কাছে আছে আপনারা নিশ্চয়ই ফাইল করেননি আমার কাছে তো অ্যাফিডেভিট ইন অপোজিশন আছে
You filed it and you give them a notice unless the exchange of affidavit is complete.
No problem at all.
How the court can take up the matter? And many matter has been included that is not ready for hearing.
I can give a notice. I can give supply a copy. There is no problem at all. And my only difficulty, my lord, why I mentioned this
You
matter.
keep it with you.
Your
And
Lordship.
if you file, want to file exception, you file in the meantime.
Supplementary, my lord.
Huh?
If your lordship is accepting the supplementary, then I'll have to.
I don't know what he has written.
I have also not served the copy. It is coming today only. The only difficulty, the petitioners are languishing for years. That is the only difficulty. They are absolutely, my lord, extremely facing extreme hardship, my lord. That is the only difficulty, and that prompted me to mention this matter. And
Your Lordship,
considering
I
this
have
on-
the Xerox copy of the original one, but it was initially filed by.
No, you try to find it out.
record the
Record the din to.
আমাদের নয়, এটা
আপনি রেকর্ডটা দেখে নিন। তো রিট পিটিশন অ্যাফিডেভিট ইন রিপ্লাই আছে স্যার অ্যাফিডেভিট ইন অপোজিশন এগুলো আমার অ্যাফিডেভিট অফ সার্ভিস তাহলে আপনি রিঅ্যাফার্ম করে দিয়ে দিন রিঅ্যাফার্ম করে দিন
Your Lordship, I have the Xerox copy. Since the original copy is missing, Your Lordship, if be permitted to file, reaffirm and file the same.
Only prayer, my lord, kindly fix a returnable date so that I can come back within a particular date. Only considering the hardship of the petitioners, my lord.
Yes, HON'BLE listen to us. Miss Sacha, what is your name?
My name is Rajashree Mukherjee. I'm led by Miss Noel Banerjee.
Mr. Mukherjee, learned advocate appearing for the state, submits that a copy of the affidavit in opposition duly prepared Acha, pair is considered and allowed. Release the matter for further consideration on 21st or 28 August. Huh? 21st তারিখ কি বেশি টাইম দিয়েছি?
Let me there on 21st.
As a 21st August, the parties are directed to exchange their affidavits in the meantime.
Number 8.
Okay, next.
Number 23.
Matter relates to the engagement of data entry operator. Here was the panel, my lord. In the panel, my lord, the respondent number 7 stood first, I stood second, and another person stood third. But it is found from the record, my lord, that the petitioner number 1, the respondent number 7, who stood first in the panel, he does not belong to the same block.
Where is the notice upon the private respondent?
I have served notice, my lord, therefore my opposition reply has been completed.
Yes.
And last occasion, your lordship,
Notice in terms of dated 8th May 2025.
I have served, my lord.
Although the court has not said that direct you to file affidavit in service, but you should have.
Yes, Lord. I have served, my lord, as per lordship's direction, my lord, on 19th May 2025. As per lordship's direction.
And they received.
Yes, my lord.
So you should have filed affidavit in opposition.
It is delivered, my lord.
Huh?
It is delivered, my lord.
Affidavit service, you file affidavit service. Acha. Have paid for on behalf of the.
Here, my lord, one submission, my lord.
This matter may be disposed of. My lord, I stood first in the panel during the.
You are the private respondent.
Yes, ma'am. I am for the.
Who is the for the state?
That person is with me. See, his Dunia.
Tomo Basu, my lord, was there.
On last occasion, he didn't appear, my lord.
No.
On several occasions.
He exchanged affidavit.
Maybe exchange affidavit, but did not appear on the last occasion, my lord. He did not appear.
We want to recast the panel and exclude in your name.
Yes.
Why you want so?
Well, because, my lord, the respondent number 7 is not the resident of the particular block. And, my lord, to that effect, my lord, the BEAD self-help group, and I made a complaint to the BDO, and BDO, my lord, kindly come to the page, my lord, 29, my lord. I made a complaint and BDO to that effect, sought for a report from the chairman, BEAD self-help group, Sangho, Bohumukhi Prathomik Mohila Cooperative Society. Whether the respondent number 7 is the member of the society or are the resident of that block. And what to that effect, my lord, the BDO's report is very much important in this matter, my lord, because, my lord, the BDO exchanged the affidavit but did not disclose the report. And, my lord, I have got on information from the self-help group that she is not the member of that particular self-help group. So that's why her candidature is not acceptable as per the, my lord, notification. Our notification says, my lord, that is, my lord, page 18, my lord. Please, my lord.
Yes.
Yes, my lord. বিষয় ব্লক লেভেল ডাটা এন্ট্রি অপারেটর নিয়োগ সংক্রান্ত বিজ্ঞপ্তি মাননীয় সমষ্টি উন্নয়ন আধিকারিক মহাশয়ের 3 ডিসেম্বর 2021 তারিখের এত নম্বর পত্র অনুসারে এসএইচজি গোষ্ঠীর মহিলাদের মধ্য থেকে একজন ব্লক লেভেল ডিইও নিয়োগ করা হবে। আগামী 7 দিনের মধ্যে নিজ নিজ বায়োডাটা প্রয়োজনীয় নথিপত্র সহ সিল করা খামে আবেদনপত্র জমা করতে বলা হচ্ছে সংঘ অফিস কার্যালয়ে, আম্বেদকর বিদ্যালয়, সময় সাচ এন্ড সাচ। এবং দিস দ্য কন্ডিশন, মাই লর্ড, আবেদনপত্র জমার তারিখ 6 ডিসেম্বর 2021 থেকে 12 ডিসেম্বর 2021, আবেদনপত্র স্ক্রুটিনির তারিখ ও সময় 14 ডিসেম্বর 2021 to 2 PM, আবেদনপত্রের পরীক্ষার পর মেধা তালিকা ব্লকে পাঠানোর তারিখ 16 ডিসেম্বর 2021। দেন, মাই লর্ড, আবেদনকারী যোগ্যতা উচ্চ মাধ্যমিক পাস, কম্পিউটার বিষয়ে শংসাপত্র,
বয়স 18 বছর ঊর্ধ্বে, বিশেষ দ্রষ্টব্য। আবেদনকারীকে অবশ্যই হেয়ার বলো রানী রাসমণি, দেয়ার বলো বীর সংঘ, রানী রাসমণি সংঘের অন্তর্গত যে কোনো দলের সদস্য হতে হবে। আবেদনপত্রের সঙ্গে জমা দেবেন জন্মের প্রমাণপত্র ও মাধ্যমিক অ্যাডমিট, মাধ্যমিক ও উচ্চ মাধ্যমিকের রেজাল্ট কপি, 2 কপি পাসপোর্ট সাইজের ফটো, কম্পিউটার সার্টিফিকেট কপি, দলনেত্রীর সিল সহ ঘোষণাপত্র ও স্থায়ী বাসিন্দা প্রমাণপত্র। So she was the resident of that block. When the advertisement was made, prior to that, she was married with the different Rampur 2 block. She made application here, in Nolhati 2. The selection was made in Nolhati 2 block. She married in 2018 at Rampur block under Soipur village. And the clause number 5,
where is that condition that he is to be resident of a particular area?
Two condition. Number 5, দলনেত্রী শিলসহ ঘোষণাপত্র, and 6, স্থায়ী বাসিন্দা প্রমাণপত্র।
স্থায়ী বাসিন্দা permanent resident certificate or any document showing his containing
As per desire of the video, my lord, yeah, I have submitted all documents, admit card, voter card, PAN card.
But where is that condition that he is to be a permanent resident of a particular locality or particular area?
আবেদনকারীকে অবশ্যই পার্টিকুলার সংঘের অন্তর্গত যে কোনো দলের সদস্য হতে হবে। She is not the member of that member of any সংঘ, my lord, because all the সংঘs are situated at Nolhati 2 block. And for that reason, video sought for a report, kindly page 29.
So video is authority making and conducting an inquiry.
Yes, lord. Video made
whether your claim is justified or not. So I am directing the video to conclude the inquiry.
It is found from the.
It is, yes, ma'am.
It is found from the.
It is a fact-finding authority. Is the video question of certain fact? Question of fact.
Whether I am the resident of in block.
Question of fact involved. Whether the petitioner, private respondent, fulfilled the eligibility criteria for being appointed to the post of such and such or not. That the video will do.
But I am coming to lordship. Well, in this case, my lord, the Sangho is the main of my stakeholder who can certify that she is the member of my.
Video will consider whether the certificate was properly given or whether he was member or not.
Or whether I am the inhabitant of that locality or not.
Video extends the affidavit. In the affidavit, my lord, there was a 3-man committee inquired the matter. It is found from the inquiry report that she was married prior to the notice of advertisement, and she was there.
Subsequently, in another
block. And subsequently, my lord, she made a document of talaknama. So that talaknama is a doubtful talaknama.
That cannot be whether the.
So, your lordship knows it very well. Your lordship,
the authority to decide whether talaknama is forged or not.
One thing, my lord, my grievance is against the video.
And so this court is also the authority. Evidence is required. Whether this talaknama to determine this question of fact.
Talaknama they have produced, my lord. They have in the annex, the reply, in the reply opposition, it has disclosed. To that effect, my humble submission, let the matter be referred to the district magistrate. He is the highest authority of the district. He can decide the entire matter.
No, why?
Because video, since video extends the affidavit and VCO come to a conclusion that by filing the affidavit, by holding 3-man inquiry committee, so let the matter be decided by the district magistrate. I have also made representation to the DM, my lord.
Kindly see page 29.
My page 32, my lord.
3-man committee constituted by whom?
By
video. Page 29.
Video.
Madam, kindly page 29 for a moment. Video issued a letter on 9th March 2022 to the chairman, secretary, be SHG, self-help group, my lord, Sangho, Bhumimukhi, Prathamik Mohila Cooperative Society Limited, Bhadrapur 2, Gram Panchayat, Post Katwakodia, Birbhum. But that the person is the authority to consider. Let them consider. Chairman or secretary.
BDO already conducted an inquiry.
Yes.
Ah.
Yes, my lord.
Yes.
From the inquiry, it is found that prior to the incident, she was married. Prior to the date of notification, she was married and living in Rampura 2 block. She made an application.
No
and my lord,
was made, madam.
why I am submitting your lordship. One document I have procured or managed, my lord, the regulation of the Bir Sangho SHG, wherein they come to a conclusion that she is not the member of that year. But that document I cannot hand over because I have got it otherwise. That's why, my lord, the
Three-man committee constituted by the BDO submitted report.
No
report has been. That's why, my lord, asked the BDO to submit the report which he has sought in his letter dated 9th March 2022. The Bir Sangho committee has submitted the report before the BDO. So, if the BDO submits the report, anything matter will be solved by perusing the report. If report disclose that she is not the member of that particular, then I shall win. If that report disclose that she is the member of that particular Sangho,
so let the BDO consider it.
Yes, but BDO will decide.
But BDO exchange the affidavit.
Three-man committee was constituted by the
yes, BDO.
BDO asked the one self-help group.
Yes,
you produce the document.
Yes,
so the inquiry is being conducted by the BDO. So let the BDO conclude the inquiry.
BDO contact.
Yes.
Already he started an inquiry.
Whether this allegation made by my learned friend, my lords, they will decide.
Ashun.
1 minute.
If I am not entitled, I am out of the court.
Kindly come to the page 16 of my of the affidavit opposition filed by the BDO. Response number 6. Here, my lord.
Copy has been served by the state response.
Mr. Banerjee, it will get it. The issue totally here depends upon a determination of a fact. This resolution of the issue is what I say depends upon the determination of a question of fact.
Yes.
Question of fact. Whether the private respondent fulfilled the essential qualification for being appointed to the post or not.
Local resident or not that
and court will say, and since BDO has already started to make an inquiry, so let him conclude the inquiry.
But inquiry has completed. Inquiry given the report.
BDO. Yes. BDO appointed a three-man committee. Maybe let the BDO conclude the proceeding inquiry and pass a reading order. And before taking any final decision, hearing would be given to both of them.
Interested parties.
Once, for my humble submission, kindly come to page 16 of the report, my lord. What the report to 16 and 17? Both the two reports are there, my lord.
16 and 17 of
the affidavit in opposition filed by the respondent number 6, block development officer.
No copy has been served. Yes.
My lord, only one question I am submitting your lordship. One submission was I have submitting your lordship. The report submitted by the Bir Sangho has to be taken into consideration. The entire case will be solved.
Okay.
Cannot hand over.
Okay, I am asking the BDO to do it.
Definitely.
To consult the report, submitted to which would be submitted by Bir Sangho such and such.
But the resolution taken by Bir Sangho on 15th April 2022, that should be taken into consideration.
Yes.
But kindly, may I hand over this one?
I beg to have the statement.
One marking is there. Video coach report submit korte je Bir Sangho kaste report ta peyeche. Bir Sangho kaste je report ta
already a report has been submitted.
No, your affidavit is not there. Affidavit of police.
আপনি অ্যাপিয়ার করেছেন?
হ্যাঁ,
কবে appear
several
করেছেন?
times.
Well, in the first,
আপনি ছিলেন না।
kindly turn the first page, Malad. Here, Malad, the Congo decided that she has left the place. She is not residing at the particular place.
Whatever it may be, well, video will decide, the fact finding committee will decide that is the, whether I am.
My opposition is there, madam.
Huh?
My opposition is there.
Yes, I have your side.
On behalf of respondent number?
6, Malad, the video.
No copy has been started.
No. Affidavit reply is there.
At that relevant point of time, he was not appearing.
No.
কি no? আপনি appear কবে appear
But
করেছেন?
after serving the notice, they.
That affidavit in opposition not on record.
Definitely.
Yes,
After
yes.
serving the notice, I came before your lordship. Before that, how can I appear?
দাঁড়ান, চেঁচালে হবে?
It is in your chamber still now.
No, I
In
have
your
already
chamber.
submitted.
Logically, I'm
Also, my learned friend also received, he had given a reply to that.
Maybe you have exchanged.
না, তা না।
You consider that it need not be
Lordship, kindly see.
placed before the court.
Kindly see the order.
Exchange the affidavit in between us is sufficient. So you find it out from the record.
দেখি।
এই পুরনো মামলা লিখি।
এটাও তো কটা রিপ্লাই দিয়েছে? রিপ্লাইটা দিল কবে?
আমরা দিচ্ছি একটা রিপ্লাই, আপনারা অপোজিশন। তিনটে ডকুমেন্ট নাম্বার 7।
Well, I'll just take it up.
Okay, I am allocating the issue to video. Video would be proper or SDO will be proper.
Video is dealing with that.
Yes, video is already started.
Video
To
is
make an inquiry, yes.
Well, my
Acha,
against the video, that's why I sent it to the either higher authority, either SDO or the video DM.
Oh, let him live. Fact finding authority. No authority will be able to change. Sunday will be Sunday.
That is not a criteria over there. Lordship would kindly cease. That is not a criteria over there. Residential status.
Yes,
Kindly cease. The
yes,
advertisement.
it was not criteria.
It is not a criteria.
I asked Mr. Banerjee, where is that criteria that
It is not there.
he is to be a permanent resident of that
Exactly.
particular block?
No.
But that's why, my lord, in
With
the
greatest
last.
of respect, I would say, but there's no.
That's why, my lord, we can't.
Okay, তাহলে ওই জায়গাটা কেটে দিন।
My lord, my lord,
কি বলছেন?
my lord, more interesting, my lord, next page, page 17.
কি
My lord,
বললাম যে ভিডিও আচ্ছা
my lord, kindly come to page 17. My lord, kindly come to page 17.
Also called for a report from a particular member of the central group.
So আপনি ইয়ে করো তো therefore ইয়ে করবেন হ্যাঁ কি বললাম কি বলছি লাস্টে ওইখানটা কেটে দিন ইনকোয়ারি কেটে দিন আচ্ছা ইয়ে ভিডিও আচ্ছা
My lord, if residence criteria is not required, then why the inquiry report
therefore,
saying?
They made a complaint. So
needless to state, it is needless to state that the resolution of the issue raised in this writ petition hinge on determination of a question of fact.
Exactly.
A question of fact whether the petitioner, whether the private respondent made the essential qualification or not. Stop. Mr. Banerjee asserted that one of the essential qualification for the post was that the candidates must have to be resident or permanent resident of that particular block.
And also a member of the
However,
central group.
records does not support such contention of Mr. Banerjee.
Then, my lord, kindly count to one. My lord, kindly come to page 29. What is the language it is written? Well, kindly page 29. Just I'm reading, my lord. Kindly come to page 29.
The notice inviting application from the eligible candidates instructed the candidates to submit the documents showing their residential status. However, nowhere it was specifically noted that the candidates is to be candidates were needed to be
particular block
inhabitant, permanent resident of that particular.
His own annexure, page 18. His own annexure.
One submission. My prayer is there, my lord. My lord.
Stop.
Well, my prayer is there, my lord. He has given a misstatement to the employer. That was my also challenge. She is not the resident of that particular block. Yes, kindly see, my lord, prayer. See, he is giving the misstatement to the employer, so it is, my lord, offense. A employee cannot make any statement before his employer that she is not the resident of that particular.
He prayed for recasting of the panel. First one.
What is the ultimate report of the video? What is the ultimate?
Video report, nothing, my lord. Kindly see, my lord, the two reports, 16, 17 and 18, 16 and 17. And, my lord, kindly see, 17 also, what is the report? As per your instruction, we understand went to house of Nobirul Islam.
You have stated the inquiry report.
That is about 16 and 17. In the first report, that groom is coming frequently to his house after giving the talak. And next page, my lord. We met with Nobirul Islam.
But he is practically rewriting the notification. But he has attacked the panel. Let him.
Inquiry report submitted by the bureau suggests that currently the private respondent does not reside with her husband, and now he is residing with her father in her parental house.
Justice, my lord. My lord, if your lordship may kindly, your lordship was pleased to, my lord, direct the matter to take down, my lord. I am only praying, my lord, may your lordship may kindly make it not today, my lord. I'll come up, my lord, on every occasion. No,
When the matter would be called, then
my lord, on every occasion.
And
On
it is
every
the way.
occasion, on every
The way.
occasion, my lord, I was there, my lord. Just today, my lord, I was on legs, my lord. That's why, my lord, kindly, my lord.
The way to mention.
My lord, the honorable division bench has directed us to added this in the writ petition, my lord. We were not added in the writ petition, my lord. That time, my lord, ex parte order was passed, my lord. So we moved to before the division bench, my lord. And division bench, my lord, directed
this code
in this code, my lord.
So the direction.
My lord,
That the bench had
start.
Because the
Yeah, read, my lord.
bench headed by the Justice Honorable Chatterjee shall take up the matter. Bench.
My lord, second page.
Run by Justice Chatterjee shall be taken up for hearing. It is 18.
My lord, second page, my lord.
Added respondent to the I do not.
Okay.
What is the order upon the learned single bench?
My lord, there is, my lord, I am an added respondent, my lord, here.
What is the order?
My lord, order is
I
this.
like to give priority this over the other matter, to give priority to this.
No, my lord, no, I am not on that. That's why, my lord, I am only praying, my lord, kindly make it not today, my lord. Tomorrow, my lord, I'll do this.
No.
My lord, kindly, my lord.
Don't mention in this way.
My lord, as your lord.
At the time of call, you are not present.
My lord, on every occasion.
I am to entertain your mentioning in this fashion.
My lord, I am the opposite party here in my lord.
The matter stand released from my list due to my personalism.
My lord, kindly, my lord. My lord, if your lordship kindly, my lord. My lord, I am not mentioning the matter, my lord. If your lordship kindly, my lord.
Item number 17. The matter stand released from my নিয়ে আসবেন আমি এক্ষুনি সই করব
My lord, kindly, my lord.
Okay, no, go.
Deeply obliged, my lord.
Next.
24.
25.
24.
24, someone
That I am for the petitioner. I said that today I have to leave for Jalpaiguri Circuit Bench because tomorrow the matter when my lord is sitting with my lord Justice Varun Mukherjee, the matter was fixed for hearing from tomorrow. It is live appeal.
In the morning at the time of mentioning, you will take one stand. When the matter will be called, then you will take another stand.
No, my lord. I prayed that.
Who is your other side?
Lordship, I am appearing for the respondent. Your Lordship, it must have been mentioned without notice.
I
was not aware it was mentioned without notice.
It was mentioned in the morning.
Without notice, Your Lordship.
I am mentioning right now in presence of you.
How the matter is called?
At his presence, I am mentioning. Taking time.
এবার সকালবেলা ওইসব মেনশনিং কারোর করা যাবে না, এন্টারটেইন করা যাবে না। Yes, tell what's the matter about.
I start.
Yes, why not?
I find any item.
Oh. Bottom.
Passover. Passover. Short Passover.
Not today, would be placed at the bottom.
My lord, may I place to lordship? My lord, tomorrow I will be there. I have to go.
Next. Next 25.
Right, please, Your Lordship. Now for the petition. But can you recollect, Malak, this
transfer?
Yes, Malak, this matter pertains to transfer of the school teacher. Lordship, on the pursuant to Your Lordship's earlier direction, Malak, there was the affidavit in opposition I received from the school.
I am filing the opposition on behalf of the school.
Use the reply to that effect. AJ. Reply.
Any affidavit exchanged by the parties are taken on record.
But here, my lord, logically for my lord's quick recollection.
Affidavit exchanged by the.
I'm sorry.
Acha, the APDB in opposition filed on behalf of the respondent number 2 and the
Three vacancies or 5 vacancies. So here there are 3 teachers in the school only. So he is one of them. Basically, he is the head of the institution right now because the other being the senior most teacher. So be that as it may, my lord, he applied for transfer on the ground of his wife's illness. So my lord, his transfer application as pursuant to the rule, my lord, was verified by the BMOH concerned, because my lord, the rule says that if there is any doctor of the school managing committee, he will verify whether the person has actually got the disease or not. So that verification has been done in this case, my lord, by the BMOH. Now, my lord, the rule specifically says that after this verification, there is no other thing that can be considered, but this application for transfer has to be forwarded to the district inspector for any further verification by the CMOH concerned. So, my lord, this is the situation right. So now, my lord, my application has been kept pending at the end of the school back from 2022 itself, so which, my lord, led the petitioner to come before this honorable. So now, my lord, what happened, my lord, pursuant to this honorable court's direction, I have received the affidavit in opposition used by my lord senior's client by the school. It says 2 things. 1, pupil-teacher ratio, that is less. So this is why I could not, my transfer application could not be forwarded to the district inspector. 1. And 2, the school here, my lord, is being represented, my lord, by the sub-inspector of schools. Because, my lord, what happens in these junior high schools, there cannot be any managing committee for these junior high schools. So always, my lord, there are ad hoc committee, and the sub-inspector of that particular circle is regarded to be the ex officio member secretary of that particular ad hoc committee. So here, my lord, the school is being represented by the SI, who is the ex officio member secretary of the ad hoc committee. So he says his second point is that myself being the head of the institution, I could have forwarded my application to the district inspector. But since it is the SI, he says that he doesn't have the authority to forward the application to the district inspector. So that is his second limb of argument. So, my lord, my answer to that, my lord, first part, it is no more res integra, because this honorable division benches, this honorable court's division benches, moreover, the rule is very much vocal about this situation. That yes, if the teachers, if he is a single teacher, or if it doesn't commensurate with the role strength, pupil-teacher ratio, yes, transfer application will not be forwarded. But exception is medical ground transfer application or any other special ground transfer application. So if it is a medical, it is very specifically written in the statute, Lord, you have seen in several other matters, that if someone applies for transfer on the medical or special ground application, then all these embargo of single teacher or pupil teacher ratio mismatch and everything will not be looked into, and his application will have to be forwarded to the district inspector. That is the rule. So, and second part, about this objection of pupil teacher, my lord, I will be also relying upon very recent decision of this honorable division bench of this honorable court, where a strikingly similar situation where the school denied to issue the no objection on the ground of PTR. So, my lord, the honorable single bench directed that it has to be forwarded, and that direction, my lord, was challenged by the school before the honorable division bench, and that was dismissed with cost by the honorable division bench by saying that they cannot just do something or pay something which is not there in the statute itself. So, my lord, this is with respect to the first of their ground, that pupil-teacher ratio cannot be done. And with respect to the second one, that this sub-inspector of the school is not authorized to transfer or forward the application for the school teacher to the district inspector, I have annexed in my affidavit in reply that this sub-inspector of school has forwarded other, my lord, teachers' application for transfer to the district inspector with respect to other institutions. So, my lord, this is my respectful submission. Only just I tell you, Lord, 2 or 3 pages to my lord. I'll just take your lordship. Thereafter, my lord, a senior friend will be placing my. My lord, if I request your lordship, my lord, to see page number 24 once of my writ petition.
Yes.
24, my lord, is the extract of the portal which I get from the internet. My lord, why I take your lordship, my lord? Your lordship will see in the middle of the page, reason, it is written. Middle of the page. Reason, medical reason, son, daughter, spouse.
Yes.
Your lordship got that?
Yes.
So this makes it evident that my application is on medical ground.
Hmm.
Then my lord kindly turns over to the next page. My lord, this is also, my lord, the status of this portal which says that when the application was forwarded, backwarded and everything.
Hmm.
My lord, this starts from the bottom.
Hmm.
So lordship will see if the top, let us say, my lord, the serial number 1, that is the last situation that has happened.
Hmm.
So lordship directly cannot sees serial number 1. So it is 13th of February 2022.
Hmm.
Applicant forwards the application to the head of the institution.
Hmm.
So thereafter nothing happened. So this is the last situation. The previous, all these, my lord, are the previous situations. I'm not taking a lordship to that. I am just aggrieved by the last one. So which is applicant forwards to the head of the institution on 12th of February 2022, and they did not forward my case to the district inspector. My lord, the third document that I was referring to, your lordship will kindly comes to page number 50, the last annexure in my writ petition, the last page in my writ petition.
Yes.
My lord, that is the certificate, my lord, which is issued by the BMOH. It says, this is to certify that Manisha Datta, wife of Pallab Karmakar, resident of village and post office such and such, has been suffering PCODs, is a gynecological disorder, syndrome for last 1 year, and such and such cycle disorder. So these are all gynecological disorder. So she needs proper treatment and family care from the family members. So this is what is the certification of the BMOH, by saying that my wife is suffering from gynecological disorder. Now the decision will be taken by the district inspector, again by verification by the CMOH, and thereafter it will be forwarded to the School Service Commission. So this is the situation, my lord. I just came before your lordship. Only now, my lord, the rule. If I request your lordship to see the rule once.
Yes.
My lord, this is the last amended rule. My lord, I have also annexed in my writ petition, but they are not that legible, my lord. This is why I was just taking your lordship to the
Yes.
compilation. So,
Yes.
my lord, I just request your lordship, my lord, to see the next page, the amended rule 6. Running page, my lord, 60.
Yes.
Yes.
See.
Yeah, 6. It says procedure for submission and consideration of the application. Oh, very, very well. Before that, my lord, kindly sees the grounds for transfer, which is from the previous page. That is 4A. I'm sorry, my lord, I ought to have taken your lordship.
Yes. Yes. Yes.
4A says any incumbent or his or her spouse, daughter, his or her son, daughter, spouse suffering from malignant diseases, severe heart diseases, renal failure, thalassemia, replacement of organ, serial gynecological disorder, causing serious problem in attending the school. So this is one of the ground, 4A. My lord, B is a physical disablement. C, female incumbent facing problems. D, more than 57 years of age. And E is something else. So now it comes down to C, 6. 6 says an incumbent may apply for transfer on the ground mentioned in Rule 4. The respective authorities involved in the process transfer is such as School Managing Committee, District Inspector of School, Central Commission, Central School Service Commission, West Bengal Board of Secondary Education. Upon submission of the application, the authority of the SMC, which is School Managing Committee, shall, well, it comes down to C, consider the number and subject teacher and roll strength. If resultant vacancy of the school in particular subject becomes 0 or not commensurate with the roll strength, the authority of the School Managing Committee shall not forward the application. My lord, then my lord comes down to E. E says dispense with the provision of C and D of this sub rule for application made on grounds mentioned in Rule 4A to D. So my application is 4A. So my lord, it is the settled situation my lord, created by the statute itself. Only my lord, I was just referring to your lordship, my lord, one judgment of this honorable court. My lord, as I said, that strikingly similar situation was there. Here your lordship will see this ground of rule 4, rule 6, these are all my lord quoted here. And then my lord, directly my lord comes, your lordship my lord kindly comes internal page 6 of the judgment.
Yes.
So it in the middle of the page it starts, before we proceed to interpret. Has your lordship got that? Before we proceed to interpret the various clauses contained in 4 and 6 of the said rules, the undisputed facts which would throw light thereupon are required to be adumbrated. Now, admittedly, an application for transfer was filed by the writ petitioner that she is suffering from serious gynecological disorder causing such and such problem. We find dissent whether the managing committee considered this such and such. Be that as it may, even if we take it, the last application have to be considered by the managing committee, as both the applications are founded upon the same set of facts. The resolution taken by the managing required to be scrutinized. Here, my lord, the managing committee decided that no, it will not be forward. In my case, it is kept pending. Based upon the aforesaid undisputed position, facts and circumstances, the provision contained in Rule 4 and 6 of the rules, it is manifest that the moment the application for transfer is filed, disclosing the disease mentioned in Clause A4, Rule 4, the school managing committee is mandated to verify the service records and other details of the applicant, and also to find out whether any case are pending or being contemplated against the said applicant is under or he is under order of suspension. Clause C of 6.2 provides that in the event number of subject teacher and road strength would invite the strength to be 0 or not in commensurate with the road strength, it is not obligatory on the part of the school managing committee to forward the state application. The legislature, but here my lord, I was just putting stress on. The legislature, by incorporating E of Rule 6.2, was conscious that the medical ground cannot be equated with the other general grounds at its stand on higher pedestal, and conveyed the laudable message that C.D. of 6.2 shall not apply to cases where the transfer is sought on any grounds envisaged in clause A to D of 4 of the said rules. Obviously, the reason being the medical emergency sees no boundaries and does not invite an inhuman approach even in the executive fiat. The procedure to be adopted by the school managing committee is also provided in Rule 6, as mentioned here in above, to the effect that the moment an application is filed, the school managing committee shall cause such application to be examined by the doctor appointed by the said committee if the transfer is necessitated by the disease suffered by the applicant, as mentioned in 4 of said rules such and such. The statutory rules have provided the obligation and adherence thereof, which cannot be undermined and whittled down as per the whims and discretion of the school managing committee. The school managing committee is required to adhere to the provision, and any transgression or departure therefrom would entail such decisions susceptible to be interfered in the in exercise of the powers under Article 226 of the Constitution of India. So had it been the case that there is no transfer policy of the rules framed by the administrator in order to run and manage of the committee, the said decision of the authorities are tested on the principle of natural justice, reasonableness, and rationality. Once the statutory rules are framed, the state government, incorporating the exhaustive provision relating to transfer, the respective roles and responsibility enshrined therein, cannot be permitted to be bypassed and or violated, but the strict adherence must be ensured. But now the situation here, the particular matter, and thereafter the appeal is dismissed by imposing 50,000 rupees cost. So, my lord, I just beseech your lordship, my lord, this is this part of the non-commensurating with the road strength. My lord, last document that I was just referring to, my lord, which is there in my affidavit in reply. Kindly seize that once.
Yes.
My lord, they say that
Page 10.
Yes, yes.
Yes.
Great. So they say that it is, my lord, the resolution of a different school altogether.
Page 10.
Page 10, my lord.
10. Oh.
10. I think 11. I think it's 11. Oh, yes, yes.
Sorry, Lord.
Yes.
Full number gets me.
Yes, resolution.
My lord, this resolution says that this particular SI has granted no objection with respect to another assistant teacher of another school. So the point that he takes that SI school cannot.
That's not the point. That's not the
forward
point taken by us.
in
Somehow
the
he has
opposition.
misunderstood.
In the opposition.
Somehow he has misunderstood. That's
Take
not our
notes, be
point.
that as it may. So
But our point is something
so
else.
this is my I doesn't conclude with this. So this is my respectful submission before your lordship. Since the statute as well as the settled position, it is no more in res integra that the school cannot stand in the way.
Kindly
This
come
is
to
all my
page 24 of the writ petition of my learned friend. This is the history of application made by the petitioner. Or what is the name of the petitioner? Pallab. What is his status? If I am not wrong, he is the head of the institution. Now, kindly come to page 24.
Yes.
Page 25. But it starts from bottom. The first that was forwarded by the applicant. Who is the applicant? Pallab. To whom? To the HOI. To Pallab. Just the above. Now, that was backward by whom? HOI.
No, that time Pallab was not there.
Yes.
Recent was
Since 2022.
No.
If I'm not wrong.
তখন ছিল না।
Yes, no, that's our specific claim. That's our specific claim. Being the head of the institution, it was forwarded by you, backwarded by you. And that continued till top, my lord, kindly have a look. Ultimately, applicant to HOI. Then stopped. That was not forwarded by the HOI to the DI. The reason is why? The reason that is that particular medical report. Kindly come to the medical report at page 50. My learned friend has already, my lord, shown before lordship the rules. It says malignancy and other things as well as serious gynecological issues. But what is page 50? Does it says that she has been suffering or his wife has been suffering from serious gynecological problem? There is no such reflection. What it says has been suffering from PCOD. PCOD, polycystic ovarian disorder. And my lord, for last year, so and so. It doesn't say it's a serious gynecological disorder or anything more. That's the reason this person himself didn't forward the same before the DI at that point of time. Rather, he came before lordship in 2022 itself. Now, how could he blame now? Had it been a case that this was not done by the school authority, you were holding the portal details, the user ID that you had. That's my specific case in my opposition, that the applicant, page 4, paragraph E, in my opposition.
Yes. Page
Page
4.
4, my lord, paragraph E.
Yes.
That the applicant and the teacher in charge of the school is the same person, that is the Pallab Kumar, who made his application on 13th of February 2022 after getting the certificate of BMOH, and both the salary portal and Utsosari portal was maintained by him. As login ID, credential was with him. It was not known to the secretary of the said junior high school, and the OTP for login was and is forwarded to in his phone number only. So the secretary ad hoc committee could not do anything regarding objection statements put in the online file. So objection, if any, that was made by him himself. And all the comments and backwards and forwarding were clearly maintained by the teacher in charge and the applicant, who are the same person. If that's the case, where the objection is and against whom? Is he fighting the battle in between himself? In one character, I am the applicant. In another character, I am the teacher in charge. So let him fight. Let him fight the battle, my lord. What our role is. And this has not been, otherwise contradicted by my
Now,
learned friend.
what rule says head of the institution will submit application to whom?
DI?
Directly.
HOI to DI.
In case of his own transfer, he will submit a application to whom?
Well, he is the person who is dealing with this portal. Now the resolution of managing committee is required. Managing committee resolution is required. Now here is a case that no such resolution is there. Because the managing committee was not there, it's under the management of ad hoc committee. The SI is the person. Now he himself did all these things. At least 4 transactions or 5 transactions are there. Now all on a sudden he stopped. And he is before Lordship. He is before Lordship now.
Oh.
Alleging that this is not forwarded by whom? Is there any objection raised by the school authority? Let him show that there was any objection raised by the school authority. We were not dealing with that portal. The portal was being dealt with by you.
So now portal is suspended.
It is suspended.
Operation of the portal is under suspension.
He made this mess.
So he will make application, a press or offline application.
Let him make.
To the secretary of the school.
At my learned friend.
To the secretary of the school along with the requisite documents. If the secretary of the
school liberty granted by your Lordship, he can.
May I not answer to my learned senior's question?
Yes.
Or I'm not being able to understand, my lord, who has engaged my learned senior. Is it my client? I do not know that.
No.
So, my lord, now.
No. I am by the managing committee.
Managing committee.
There is no managing committee. There
No,
can't
you have member secretary ad hoc committee. That's
yes.
member secretary.
That is exactly what I'm saying. Member secretary of the ad hoc committee.
Yes.
He is the incumbent who gives the NOC to the person who makes the application. If it is HOI, it has to be the member secretary because he is heading the ad hoc committee.
Where that application is now?
Now, my lord, I just
Is this question now?
If there is the HOI here for the purpose of my application, who is the teacher in charge before the school right now? So it is only, my lord, it is it's my humble understanding, my lord. No incumbent will make his application, and it will be it is, my lord, completely. It's kind of not permissible even.
You have done this.
But to deal with this, even if it would have been there in my hand, I would have definitely forwarded it to the district inspector. But this would be completely absurd from my part.
Okay, now you send an offline application along with the document. DI will consider.
We shall forward the same before the CMOE.
This is what I'm just playing. This is exactly what I played now. That since, my lord, I think my lord senior friend is representing this SI of the schools.
Yes.
Yes. So if the SI of the schools are there before your lordship and he says that he doesn't have any objection, so I don't have any grievance.
No, doesn't have any objection if you make a fresh application.
Fresh application before the DI.
Yes.
Yes.
Before the school authority.
I can't be that.
Before the school authority.
No, understanding that I am
for the school authority.
being able to
Let him apply before the school authority.
Now I have made this application.
So before the secretary of the managing committee in normal case.
Managing committee is not there.
Now in your school there is no managing committee.
Ad hoc
committee secretary. So secretary of the ad hoc committee who is now running the managing committee of the school, you will submit application before him.
Before the concerned BMOH or CMO?
No, BMOH forwarding is done already.
No, so that's up to 2022. Whether that substituted or not.
Now comes. Now, my situation comes. Now, my the SI says that he has got some problem. So, my lord, now this is exactly where I'm joining the issue. Since after the BMO it says the SI is under the obligation to forward this application, which he did not do. This is like
said. Yes.
So I just beseech your lordship today, as it stands, that he says that he did not backwarded my application. It is what myself who did.
Yes.
So since he did not do it, and the BMOH certificate is on record, the BMOH certificate has to be forwarded along with my application in offline mode to the district inspector by the SI of the schools. Record my submission.
BMOH certificate doesn't say
my own application.
Serious illness.
Because
what is the rule? I am just want to say that this head of the institution or headmaster himself want to make application for his own transfer, then what procedure is need to be filed? Follow.
Subject to correction, the rule is silent about that. So it is always, my lord, the school who is being run. So a school, lordship knows better than anybody else, the school is run by the committee and also by the head of the institution.
Till
So
the portal
here,
system was there.
The junior high school, as per the setup, my learned senior friend for the state will be apprising your lordship that they are.
Whereupon they are asserting that your application, there must be some recommendation by the managing committee.
But managing committee is not there in any junior high school, in any school in the entire state of West Bengal.
Instead of managing committee, there is something else, ad hoc committee.
Yes. So
Then-
there can't be, there is, the rule is, there cannot be any managing committee for the junior high school. The rule is, there will be an ad hoc committee, and the rule is that the SI of the schools will be heading as an ex officio member secretary of that management.
Yes.
So here, well, in case of our salary and everything, myself being the teacher in charge, it is the endorsement of the SI of the school is always required for the purpose of forwarding it to the district inspector. In all other administrative matters, it is the SI who has been set up as, my lord, an ex officio member secretary. So he has to do this stuff.
SI, if the SI refuse to forward your application, he must assign the reason.
That's not the fact.
Reason?
He did not assign the reason.
Well, who forwarded?
It is a wrong.
HOI.
My lord,
You submit a fresh application to the SI of school,
Yes.
who, as a secretary of the ad hoc committee, ad hoc managing committee, will consider and
he
take
has nothing to
medical
consider. This is my-
opinion, pay medical
cannot.
opinion from the medical expert.
He cannot do it now. He cannot do it now.
Now, why?
I tell you, lordship,
It's
because
a
of the reason
irrevocable disease of
already, it is
2022.
already there of the BMO is concerned. Now I will be verified again, because this is of the 2022. I will be once again verified by the
Yes,
CMO.
recent medical
By the
document.
CMO, it's not by the BMO. This is where, my lord, the problem lies.
Actually, even in case of permanent disablement also, certificate
to be there.
A certificate
It has to be latest.
declaring that this person has suffered a permanent disablement also. This person is called to report after a particular period.
5 years, 10 years.
Particular period.
This is what
So
we pray.
you submit with the recent medical document,
I tell you,
and they will.
it has to be done. Now, my lord, since the BMOH part is done, it has to be verified by latest, by the CMOH, not by the BMOH concerned. So my prayer before your lordship, it is such laudable stand of the school or the SI that my wife's medical condition once again has to be verified. Has to be verified. I also say yes, but has to be done by the CMOH concerned through the district inspector. What is the harm in it?
Certificate of July
It is the CMOH.
2022.
Yes, absolutely.
We have to proceed
Let us say
in July 2025 based on
let us
that.
say, my lord, if the CMOH finds that my wife doesn't have the problem,
What's
my
the
application will be
difficulty of my
rejected.
learned friend?
Okay, Mr. Jahan,
rejected.
even if he is permitted to make an application before the district
Yes.
inspector of school, the district inspector, along with the recent medical document,
Yes.
the district inspector of school will verify the
Yes.
same and obtain the opinion from the medical expert, CMOH, whether his wife suffers from serious,
Lordship,
Yes,
lordship,
ah,
lordship.
such a serious problem.
No further argument.
Yes,
I'm also in agreement with
and
that.
that he will not be able to attend the school.
Yes, the matter is resolved now.
Kindly do that. This is what I pray.
Yes.
CMOH, let it be verified by the CMOH. Yes.
The present writ petition has been prepared, praying for the issuance of a writ in the nature of mandamus, commanding the concerned school authority to forward the petitioner application for transfer on medical ground, to the district inspector of schools. Stop. Mr. Royal, Learned Advocate, repenting the petitioner, submits that currently the petitioner is functioning as the head of the school Advanced by Mr. John. Acha. He considered he considered with the submission that if the such and such petitioner is granted liberty and such, the state will have no objection, would have no objection. ঠিক আছে? That's all. Any কাগজপত্র নেই। Any next. এই ওইটাকে ছেলেটাকে বললাম ওটা কাটবেন না, ওকে ডাকবেন ও যদি আসে, আর ওটা
Mr. Panda is engaged in another court, so kindly make it not today.
Oh, item number
26.
26. Okay, not today. আর হবে, আর হবে, হ্যাঁ?
Before the performer responded 11 will.
Okay, not today. Next. এটা not today করে দেবেন, ওইটা কেটে দিন। হ্যাঁ, ওই ছেলেটাকে চেনেন, বলে দেবেন যে বলেছে তোমার মামলা রিলিজ হবে না, ওটা not today করে দেবেন না, ইয়ে করে, হ্যাঁ, একজন হিয়ারিং এ দিয়ে শেষের দিকে। হ্যাঁ, yes.
7.
In item 27. I'm for the respondent corporation, my lord. In item number 27. My senior, Ms. Chottoraj, recently had an operation, so I'm praying for 4-week time, my lord.
Lord, this is the matter where, my lord, from 2008, a considerable amount is lying outstanding in spite of my repeated representation made to the state authority, my lord, has not been met. Your lordship was pleased to observe that the state government should be added as a party. And on my oral prayer, the state government through the Secretary Transport Department was added as a party and they have been served. In spite of service, my lord, none appeared on behalf of the state. Although the respondent number 1 and 2, they appeared. Your lordship's observation was that unless the fund is provided by the state government to the respondent number 2, the petition.
Oh, municipality.
No, my lord.
Certain work order was issued to the by the municipality.
This is a tender matter. My lord,
And the state is now taking plea that the municipality without
no.
obtaining sanction or something like that,
No, my lord.
issued the work order.
This is a tender matter.
Yes.
Tender was accepted by the respondent number 1. I completed the job. Chief Minister inaugurated the bridge. Completion certificate is issued in 2008. I was paid the part payment of the tender amount. Balance nearly 6 crores is outstanding. I made repeated.
How much?
6 crores.
6 crores.
Nearly 6 crores. I made several representation to the respondent number 1 and 2, my lord, and the respondent number 1 requested the respondent number 2 disburse that amount. At that juncture, the writ application was filed. Your lordship's observation was that although the respondent number 1 and 2, they were represented before your lordship, but the fund to be provided by the state government through transport department, and state government was added as a party. They have been served. None appeared on behalf of the state government. Then, my lord, by an order dated 14th of May 2025, your lordship was pleased to direct me to serve a notice upon the government leader. My lord, in compliance of your lordship's order, my lord, I have given notice. That is your lordship's last order.
It is with record. এটা দিয়ে দিন, হ্যাঁ।
Now, my lord, notice was given to the learned GP on 15th of May. My lord, I do not find anybody from GP, my lord. Is it your lordship's pleasure to take up the matter tomorrow, so that I can also
Tomorrow.
make a request to learned GP, my lord, to make a representation?
Mr. Mukherjee is appearing in this matter. Item number
27, my lord.
27. So, Mr. Mukherjee, you appear in this matter. Huh?
GP এখন নতুন যে GP এসেছেন
On 14th May 2025, লিখুন অরবাবু, on 14th May 2025, comma, when the matter was last taken up for hearing, then this court concluded that the presence of the representative of the Secretary, Transport Department, Government of West Bengal is necessary for effective adjudication of the writ petition. Stop. Accordingly, liberty was granted to the petitioner to impeach the Secretary of that department as party to this proceeding, and the petitioner was directed to serve a notice to the office of the learned government pleader intimating the next date of hearing of this writ petition. Stop. Mr. Bose, learned senior advocate representing the petitioner, produce the notice and submits that the notice was duly served to the office of the learned government pleader. Stopped, however, despite receipt of such notice, the Secretary, Transport Department, Government of West Bengal is unrepresented. Stopped. I find Mr. Mukherjee, learned additional government pleader, who usually appears on behalf of the state, is present in court. I request Mr. Mukherjee to appear in this matter on behalf of the state and to avail necessary instruction.
I shall furnish the copy of the writ application to Mr.
Stop.
Mukherjee.
Petitioner is directed to serve a copy of this petition along with all annexures thereto to Mr. Mukherjee in course of
Tomorrow, my
by tomorrow. List the matter when 6 courts. He has executed the work assigned to him, completed the work. Now he is moving from pillar to post. Give my money, give my money, give my money. One Transport Corporation Department, one Secretary to the Transport Department.
When Mr. Mukherjee is there, my lord, I don't.
Mr. Mukherjee.
He will certainly.
You are lucky, most probably. Your lady luck is shining at the end of the day. And hence you got Mr. Mukherjee.
My lord, your lordship kindly keep it on Wednesday week. Wednesday week, my lord. In the meantime, I shall serve the copy to Mr.
Mukherjee. I list the matter for further consideration on Wednesday week.
On 6th of August, my lord. If it comments to your lordship.
6th of Wednesday week. হবে গাদা ভর্তি সব না এমনি যদি থাকে 13th
of
13th, yes.
My lord, may this matter retain the same position, my lord.
It will be time fixed করতে হবে না, স্পেশালি ফিক্সড ম্যাটার বলে দিয়ে দেবে। ওকে, স্পেশালি ফিক্সড ম্যাটার। Yes, next আর হবে
Grateful, my lord.
আজকে আমার 8.
Your Honor, I am for the petitioner. My senior, Mr. Dibyendu Chatterjee, is busy in other courts, so I pray for not to them, Your Honor.
It will be at the bottom of the list. Yes, it will be at the bottom of the list. Nothing can be done. Everyone is to be given opportunity. Okay, tomorrow at 16. What matter, Mr. Sen, you have? When it has 7th August, let it die. Oh, okay. You make the submission in their presence on 7th. Then what will happen? Ultimately, decision will be taken. Most probably, what is your matter? 29. 29. Whether it should be,
By Mr.
Siddharth.
So this is the matter, my lord, which was mentioned. Then my lord was kind enough, my lord, to upgrade the matter because my lord, this has, my lord, a pan West Bengal, my lord, ramification. My lord, I just indicate, my lord, what is this matter all about? My learned friend is. Oh. My lord, there has been a change in the, my lord, grade pay of, my lord, the state government employees. Now, my lord, the grade pay has not been given, my lord, a retrospective effect either, my lord, actually or, my lord, notionally. Milord, as a result of which, what has happened nowadays, Milord, the juniors are getting more than the seniors at places. Somewhere, Milord, they are getting, Milord, at par with the seniors. So, Milord, seniority is at stake. Milord, there is, Milord, widespread, Milord, agitation, annoyance because of, Milord, this decision taken. Now, Milord, we prayed, Milord, in our writ application that, Milord, this should be, Milord, rectified. And, Milord, this should be given, Milord, an actual effect with a retrospectivity. Milord, they came up, the state government, Milord, they have come up, Milord, with an opposition. Milord, wonderful in the opposition, Milord, I say, Milord, very honestly, they have accepted, Milord, the fault on their part. So, Milord, the matter has now, Milord, it can be cut short.
Yes.
But, Milord, if the matter is, Milord, lingering, Milord, since 2023, and, Milord, we are not being able now, Milord, to reach the clients.
Admission on, degree on admission.
Almost.
That 12 will 6.
Almost. Now, they have used an opposition, they have used a report.
So, if they accept the contention,
But they have.
But problem is who is appearing? Mr. Advocate General.
Mr. Arindam Chatterjee was representing.
And Lipika Chatterjee.
I am appearing on behalf of Mr. Arindam Chatterjee, Lordship.
And
yes.
Lordship, due to some personal difficulty, he couldn't be present before your Lordship. Lordship, kindly adjourn for today.
Milord, I would not have stood in the way, but the difficulty is this is possibly the second or third Milord consecutive occasion. Milord, kindly pass Milord a peremptory order indicating that Milord on the next occasion, if Milord they choose not to appear, Milord, we can proceed with the matter.
You're going to hard, Mr. Banerjee, senior advocate.
No, Milord, I am not.
Learned advocate appearing for the petitioner. Stop. An adjournment has been paid for on behalf of the state by, what is your name? Lipika Chatterjee.
Suchita Banerjee.
By Miss Banerjee. Stop. Mr. By Miss Banerjee. Mr. Banerjee has pointed out that the adjournment has been taken on behalf of the state at least on 3 occasions.
2-3 occasions.
At least,
yes.
At least on 3 occasions. Stop. In view thereof, as a last chance, the matter stand adjourned. Lease the matter for further consideration.
And Milord, kindly upgrade this matter, Milord.
As specially fixed matter,
yes.
As specially fixed matter, ফাঁকা ডেট যদি কম মামলা আছে No. 19 to 19. On 19th August.
19th. Wait.
Under the heading special fixed matter. You inform your senior, okay?
Kindly, my lord.
You inform your senior.
Grateful, Lordship.
Okay, they are saying that you have almost admitted their claim, admitted their case.
But since my lord, this matter is now going to appear as a specially fixed matter, my lord, kindly indicate a time so that my lord, we can also my lord come.
It will within the reachable.
Wait. Grateful.
I have got very useless here.
19th.
So far as item number 18 is
Great.
concerned, it was listed today. It was yet to be taken up. But the learned advocate on record could not appear since another matter.
It will appear. Yes, in the morning, I shouted at a junior that they started mentioning. Although I shouted, I said that it would be released, but I have not. It would be your matter, his matter, and the matter which has been adjourned today. It would be placed under the heading adjourned hearing. Okay, adjourned hearing thereafter. On that date, adjourned hearing means there may be a chance you can survive your case. You can save your case, and on that date, if you remain absent, dismiss for default.
Item 18.
But item number 17, if you know the year, you tell the boy, although I express my annoyance, but that the matter stand released due to my personal reason. However, I shall not pass that order. Okay? Okay. It was called. It was called. No, not go out of the list. I never said go out of
number 21.
I place it to appear under the heading hearing. It was specially fixed. So that special treatment you will not get very further.
Item number 21, your lordship.
Your matter was given paper, was treated as a specially fixed matter. But that special treatment you will not get. What can be done? Again mention that.
Item number 21, your lordship was pleased to direct it to go down the list, my lord. My lord, I could.
Adjourn hearing. Adjourn hearing.
Let me kindly doesn't go make.
Look, one thing you are coming that the person whose matters are running in the list at the bottom, they also should get chance. Otherwise, the person who matters appearing at the top of the list will go on getting more than one chance.
This was my first chance. This was my first chance.
Okay. They will not come. They have got a priority.
I did not offer an explanation to that, my lord. That was my fault, my
If
lord.
you don't come, the matter will be
I did
placed
not
at
offer
the
an
bottom of
explanation,
the
my lord.
list.
If my lord can kindly make it
Do your case.
My lord,
On 7th, Mr. Sen came. Mr. Sen came. I don't know regarding inspection. Most probably another problem cropped up. But Mr. Sen came. The matter has been fixed on 7th. I stated, Mr. Sen, you come on that date. Make your submission whatever you want to make in presence of other side. Then, in presence of both sides, the appropriate order shall be passed. No, not
before your lordship rises.
You are coming one time, Mr. Sen. Now just left the court. Now you are coming. It is not.
Lord, before my lord rises, Lord, this is with respect to Lord the extension of time for Lord holding that inspection in the medical council matter.
In presence of your other side, whatever, maybe the extension, maybe revocation, whatever you want.
Lord,
On that date in their presence.
Lord, he is your
Don't
senior
ask anything extra.
My senior is here.
Your senior is not other side.
Other side Lord, I'll put him on notice.
Okay, I stated same thing to Mr. Sen.
I'll put him on.
Mr. Sen came and another Mr. Sen along with who is appearing along with Mr. Sen.
Lord, I have informed Mr. Sen. I am told, Lord, and Lord, in that
Come
case,
on that date. Come on that date.
Tomorrow I'll come and mention.
One person should not be vexed twice. It is one of the key principles.
No, that's exactly
Come on
why
that
I
day.
must get that order.
Okay, come on that day. Okay, okay.
But the problem is that while, my lord, it is going on, the inspection, the other, medical council is here.
No.
Is here. Now, what happens is, my lord, we have, the medical council is here. So it allows us to mention, my lord, on that day.
On that. But
only extension or
no, on that date, on that date. On that
date,
so that matter is to be people.
Yes.
So why on that date you face the problem whatever you are facing.
No, problem nahi.
Tackle the problem.
Problem nahi.
On that date.
Problem nahi.
On that date appropriate order.
Special officer is
Okay.
Problem nahi. There is no problem.
No. No, on that date. So,